Give all the memos. Not on Monday, they'll come according to seniority. Nennede tumba ide. Breach of promise of marriage. All right. Anticipatory bail idru no. Give it will come. There are so many memos in the waiting. I can't overturn them and take yours. It will come. Nothing. Bail idiyalla. Bail idre yaru harassment ಮಾಡ್ತಾರೆ. Yes, ಅದು ಕೊಡಿ. We'll see. Give it. Tagged with? ಹೌದಾ? ಹೆಂಗೆ? ತಗೊಳ್ಳಿ ಅದು. ಯಾವ್ದದು? ಮೇಡಮ್, this is what I told you. The Russia. ಟ್ಯಾಗ್ ಆಗಿದೆಯಾ? ಓ ದಿಸ್ ಇದಕ್ಕೆ ಟ್ಯಾಗ್ ಆಗಿದೆ ಮೇಡಮ್. ಐ ಥಿಂಕ್ 7A 13 ಡಿ ಟ್ಯಾಗ್ ಮಾಡಿ ವಿಲ್ ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ಎಸ್. ಕೊಡಿ. ಗಿವ್ ಮೆಮೋಸ್. ಮಂಡೇ ಯಾವ್ದು? ಸೊ ವಾಟ್? ಆಯ್ತು ಕೊಡಿ. ಅದು ಮಂಡೇಗೆ ಹಾಕಿ ಮೇಡಮ್. ಅದು ಅರ್ಜೆಂಟ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ. ಅದು ಕೊಡಿ, ಮಂಡೇ ಕೊಡಿ. ಕರೆಕ್ಟ್, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್. ಕೊಡಿ. ವೆರಿ ಗುಡ್. 20th ಮಂಡೇ ತಗೊಳ್ಳಿ ಮೇಡಮ್. Give it, madam. Give it. No, not madam. What were you doing till now? No. Tell the trial court again appearance again. Please appear. Yes, no problem. Wait. End of the list. Wait. Move it for the 4th times. No problem. Give it. Can't help, sir. Give it, sir. Give it. 3 times, 4 times mention alla madlebedi. 3 times, 4 times you can't help. If you're moving the memo will go astray. I cannot take 300 cases, sir. Can't help, sir. It will come. When it comes, we will grant. Yes, no, sir. ನೀವು ಹಂಗಾರೆ ಮಂಡೇ ಹಾಕಿ ಮೇಡಮ್. ಅವ್ರು ಮಂಡೇ ಹಾಕಿ. ಎಸ್. ಸಪೋಸ್ ಟು ಬಿ. ಸರ್. ಆಲ್ ರೈಟ್. All right, sir. We'll see. ಕೊಡಿ ಸರ್. ಕೊಡಿ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಕೊಡಿ. ಎಸ್, ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಕೊಡಿ. ಅರ್ಧ ದಿನ ಹೋಗ್ಬಿಟ್ಟಿದೆ, ಈಗಲೂ ಏನ್ ಮತ್ತೆ ಬಿಡಿ. ಎಸ್. ಏನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಲ್ಲ, ಅದನ್ನ ಅಡ್ಜರ್ನ್ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ. ಡಿಸ್ಪೋಸ್ ಏನ್ ಮಾಡಿಲ್ಲ ಗ್ರೌಂಡ್ ಮೇಲೆ. ಮೇಡಮ್, ಅದು ಸೋಮವಾರ ಹಾಕಿ ಮೇಡಮ್ ಅವ್ರಿಗೆ. ಎಸ್, ಸೋಮವಾರ ಅಥವಾ ಬುಧವಾರ ಹಾಕಿ ಮೇಡಮ್. ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ಬಿಡಿ. ತೊಂದರೆ ಇಲ್ಲ. ಬುಧವಾರ ಸರ್. ಎಸ್. ಗಿವ್ ಇಟ್ ಸರ್. ಎಸ್, ಗಿವ್ ಇಟ್ ಸರ್. ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಬೇಕಾ ನಿಮ್ಗೆ? ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ ಮೇಡಮ್. 14% ಅವ್ರು ಮಂಡೇ ಕೊಡಿ. ಹಾರ್ಟ್ ಪೇಷಂಟ್ ಬೇಲ್ ಇಲ್ವಾ? ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ? ತಗೊಂಬನ್ನಿ. ಬೇಲ್ ತಗೊಂಬನ್ನಿ. ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್ ಸರ್? ಐ ಕಾಂಟ್ ರೆಗ್ಯುಲೇಟ್ ದ ಬೇಲ್ ಕೋರ್ಟ್. ಎಸ್. ನೋ ಸರ್. ಬೇಲ್ ತಗೊಂಬನ್ನಿ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ 2:30. 2:30 ಅಥವಾ ಈಗಲೇ ಕೊಡಿ, ತೊಂದರೆ. 64. ವಾಟ್ ಆಫೆನ್ಸ್? then no problem. Yes. Learned counsel so and so enters appearance 498A. ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ? ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟಾ? ವೇರ್ ಇಸ್ ದಿ ಪೇಜ್ and paragraph first. ಹಾ ಆಯ್ತು ಮೇಡಮ್. ಎಸ್ ಆಲ್ ರೈಟ್, ಯು ಕ್ಯಾನ್ ಲೀವ್. ಸೈನ್ ಮಾಡೋದು. ಅದಕ್ಕೊಂದು ಮ್ಯಾಂಡಮಸ್ ಇವ್ರಿಗೆ ಕೊಡಿ. ಹಾ ವಾಟ್? No, 2 orders against state copy. Well, Jagdish ilva? Nobody is there, state? Yes. Where is Jagdish? Ask him to come. Copy eagle serve madi. End of the list togoli. Yes.
Serial number 63, my lord, may I make a submission?
It'll list next week. Yes. No date. Yes. Yes, Tigri sir.
Yes, my lord, 63 may not reach, my lord. On Tuesday, lords may kindly have it.
All right. Adjournment, whoever wants will get. No problem. Yes.
I wanted.
But not Ivag Bada.
Please, my lord, I will mention it. 2:30 I will mention.
Yes, yes. ಅಲ್ಲ ರೀಚ್ ಆದಾಗ ಹೇಳ್ಬಿಡಿ.
Reach ಆಗಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ 1:30 ಮೆನ್ಷನ್ ಮಾಡಿ.
Please, please.
Yes. क्या हुआ है? सिराजुद्दीन निम्दु. हाँ. What permission? You want it to be ಇನ್ನೂ ಆಗಿಲ್ವಾ? ಯಾವತ್ತಾಗತ್ತೆ? ಆಯ್ತು. From the date of release ಅಂತ ಮಾಡಿ. Being learned counsel of the petition has moved the matter for being spoken to on the score that surety is yet to be complied with. Furnishing of surety is yet to be complied with, and the moment and would seek that the ಎಷ್ಟು ದಿನ ಕೊಟ್ಟಿದ್ದೀವಿ? And 1 month to begin from the date of release on production of such surety. Therefore, the order shall be read as 1 month from the date of release on production of date of release. 1 month from the date of release. The order shall be read as part and parcel of the order dated so and so. The registry is directed to communicate this order as well to the prison authorities. Once in a while. Insofar as clause 3 of the main order of the order dated so and so is concerned, it stands modified to mark his attendance before the jurisdictional police once in a week. Yes. Any problem? Correct. ಅಲ್ಲ ಇನ್ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಕರೆಕ್ಟಾ? ಕ್ರೈಮ್ ನಂಬರ್ ಏನು? 14 of? ನಾನು ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಯಾವ ಕ್ರೈಮ್ ನಂಬರು ಹೇಳಿಲ್ಲ. ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿಲಿ ಇದೆಯಾ? ಇಲ್ಲಿದೆ. ಎಸ್ ಎಸ್, ಒಂದು ನಿಮಿಷ. Crime number 47 of 2023. In the order dated 28/6/2024, there is a typographical error owing to the mistake of the council in mentioning the crime number. It ought to have been 14 of 23 in place of 47 of 2023. The mistake is also, sorry, the mistake of the council is acknowledged by the counsel for the respondent as well. Therefore, in the order dated 28/6/2023, the crime number be replaced with 14 of 2023 and a certificate. 2020, 14 of 2020. Yes. Next. The list on 21st. Yes. Cell number 4. Is the list on 21st. Interim order subsisting will continue to the next date of hearing. Same order. Is the interim order? Pollution control. Yes, next.
6.
Same. 5 and 6 same, list on 21st, interim order subsisting will continue. Gottu covered actually, Justice Suraj our order. Justice Suraj our order. Yeah, ನಂದು ಯಾವ್ದು ಆರ್ಡರ್ ಕೊಡಿ. ಅಲ್ಲ, page 29 is not covered by this. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ? Yes, the learned counsel appearing for the petitioner submits that the, madam ನೋಡಿದ್ದೀರಾ ಇದು? ನೋಡಿಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ತಾನೆ ಕಾಪಿ. ಜಗದೀಶ್ ಕೊಟ್ಟಿದ್ದೀರಾ? If there's any change, you let me know, madam. ಹೌದು. I have myself passed this order. ನೀವು ನೋಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ you can tell me. Yes. The so and so, madam, full copy marked, both 5 and 6. All consequential benefits you will get. Petitioner is entitled to all consequential benefits. Madam, ಏನಾದ್ರು ತೊಂದರೆ ಇದ್ರೆ ನಾನು ಸಾಯಂಕಾಲದೊಳಗೆ ಹೇಳಿ, will not sign it. Yes, next. Both 5 and 6.
7.
13th. Huh? Oh, the failed trap. ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಮಾಡಿದ್ದೀರಾ? ಮತ್ತೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರ ಆ ಕೇಸಲ್ಲಿ? ಅದರಲ್ಲಿ ಇಲ್ಲ, A1 ಕೇಸಲ್ಲಿ ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರ? You did not submit this way. Then we'll do it on 7. And ಯಾವತ್ತು ಹಾಕಿರೋದೆಲ್ಲ matters? 13th in the fresh matters list. There shall be an interim order of stay of further proceedings till the next date of hearing. We'll answer that argument and then do it. Yes.
8.
Pokso. 16. Huh? No, sir. So what?
7 interim order.
That I will stay, not against accused number 1. Maybe, sir, you undergo the trial and get acquitted. 15 years, 7 months on the date of the incident, no, sir. It's all not by way of settlements. You come on merits, will answer. Parents idara illi. Parents we will stay. Because in your eloping and getting married, parents have nothing to do. That I will stay. You are in custody. Then be on bail. Maybe, sir, I'll accept that definitely nothing is there against you. Washing agala. I mean, like settlement agala. No. Sir, if both were below 18, definitely I would have cost. That's a different. Coordinate bench. An age. Supreme Court, sir. Supreme Court.
One book and back of 230.
No, sir. ಎಲ್ಲಿ ಜಗದೀಶ್ ಬರ್ಲಿ, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ಲ ಇವತ್ತು. We'll pass it over. ಬರ್ಲಿ. Let the additional SPP come.
9.
311 application. List the matter on 20, there's no representation, we have the petitioner, list them of petitioner and the respondent. List the matter on 21st in the fresh matters list. Interim order subsisting will continue till the next date of hearing. Yes, next.
10,
States SO is needed, sir. Yes. Civil suits pending. Or seeking reinvestigation. Yes. We'll have to file objections. The petitioner is seeking further investigation or reinvestigation at the hands of a different agency. The response of the state is necessary in the case at hand. List the matter on 3rd September. Objections, if any, by the state by then. In the event objections would not come about by then, the petition would be answered on the submissions of the counsel for the petitioner. Yes, next.
11,
Petitioners are A2 and A3, Kashkan. When?
When?
After filing of the petition? Yavata? Petition file ಮಾಡಿರೋದು ಯಾವತ್ತು ನೋಡಿ ಮೇಡಮ್? When, sir? ನೀವು ಫೈಲ್ ಮಾಡಿರೋದು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು 22 ಅಲ್ಲಿ. ವೆರಿಫೈ ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿ 21st ಲಿಸ್ಟ್ ಆನ್ 21st ಇನ್ ದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಏನು ಎಂಟ್ರಿ ಮಾಡಬೇಡ. ಅದರ್ವೈಸ್ ಏನಿಲ್ಲ ಮೇಡಮ್, ಸುಮ್ಮನೆ ಟ್ರಯಲ್ ಇವರಿಗೆ ಒಂದು ಚೂರು ಅಲಿಗೇಷನ್. ಎಸ್.
12,
A3 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗಲಿ. ಬೇರೆಯವ್ರು ಕೊಡಲ್ಲ ಇಲ್ಲ. ಮೇ ಬಿ. ಎಸ್ ಸರ್. ಎಸ್ ಸರ್. ಪರಸ್ಪರ ಏನಿದು ಒಡಂಬಡಿಕೆ ಕರಾರು ಪತ್ರ. Who has taken? All right, all right. Hmm. 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 Husband, I to husband. This court, in terms of its order dated so and so, had granted an interim order of stay qua accused number 3 and had directed the investigation papers to be secured. On perusal at a settlement deed, as pointed out by the petitioner, it transpires that the mother-in-law continuation of proceedings against the mother-in-law as well would become an abuse, husband, will become an abuse of the process of the law. That's not, barely, let the wife come. Yes, therefore there shall be an interim order of stay qua accused number 2 as well, till the appearance of the respondent. One amal note, one by one. Yes, one HCGP 2 emergent notice returnable by 4th September. Is avate yak kodlilla matte? All right.
13,
A567, 306 and 498 is. 304B and 498, even more lethal. Yes, sir. Kudi, papers kudi. 304B and 306. We don't know where from it has sprung. Nothing, nothing. Distant, no problems. That we'll see. Yes, paper. List the matter on 23rd. This matters list. Yes. Next.
14,
My lord, for petitioner, my lord. My lord, offense punishable under section.
Where is the laptop?
My lord, I am in another court, my lord.
Huh? No,
I am in
sir.
another.
ಇದರಲ್ಲಿ ತಗೊಂಡಿರೋ ಲ್ಯಾಪ್ಟಾಪ್ ಎಲ್ಲಿದೆ? ನಿಮ್ಮ ಹತ್ರ ಇರೋದಲ್ಲ.
please. My lord, in
Offense
the last date of it,
laptop has been taken up. Where is that laptop?
my lord, SPP, learned SPP filed investigation papers, my lord, in
That
the
is
last
what,
date
sir.
of it.
Investigation papers ನೋಡಿ ಹೇಳ್ತಿರೋದು ನಾನು.
My lord,
Anyway,
it is
papers
not
ಕೊಡಿ
within
ವಾಪಸ್.
custody.
In the meantime, next.
15,
Grateful.
Split. Password. ಸಾಯಂಕಾಲ ಬರೋಣ. Before the end of the day, we'll close it. Yes.
16,
Hmm. Stranger. ಚೆಕ್ ಯಾಕೆ ಕೊಟ್ರಿ ಮತ್ತೆ ಅವ್ರಿಗೆ? Stranger, why did you issue a check? Or he is a stranger in the mirror? Yes. Objections ಹಾಕ್ತೀರಾ? Objections ಹಾಕ್ಬೇಕಾ? ಕೊಡಿ. ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಸರ್. ನೀವು ಏನಾರ ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ಐ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್ ಹಿಯರ್. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? Anything else, sir? Correct. Where is the check? ಎಲ್ಲಿದೆ ಚೆಕ್ ಸರ್? What check have you placed before the court? Which check have you placed before the court? ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ? ಕಾಪಿ ಇಲ್ವ ನಿಮ್ಮ ಹತ್ರ? Get the check. What check have you filed? The respondent is directed to place on record the subject matter of the instrument before the concerned court, i.e. the check amount 85 lakhs. Check for an amount of rupees 85 lakhs on the next. Enjoy. Yes. List the matter on 21st. Next. In the fresh matters. Yes.
17,
ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬೇಕು. ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ಅಬ್ಜೆಕ್ಷನ್? ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಫೈಲ್ ಮಾಡಿಲ್ವಾ? ಎಸ್ ಮೇಡಮ್. List the matter on 12th. Registry to put up the objections filed, said to have been filed by the respondent. Yes. Monday, sir. Next.
18,
Idu correct. I am pronouncing that. Wait, the other one will finish this also. Your scanning machine will be released today, but the renewal ilvalla. Deemed provision ಕೇಳಿದೆ ನಾನು. Yes, ಕೊಡಿ. ಅದು ಕೊಡಿ ಇಲ್ಲಿ. ಅವರೇ ಎರಡು ಬುಕ್ ತಂದಿದ್ದಾರೆ. Section 7. Application is on time. They have in 2019. Reject or accept the application, so and so, and all. In case any delay, deeming ಇದೆ ಇಲ್ಲಿ. Yes, will allow it today. ಅದು ಸ್ಟೇಟ್ಗೆ ಡ್ಯಾಮೇಜಸ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ಬೇಕಾ? ಅಲೋ ಮಾಡಿ. ಪಾಸ್ವರ್ಡ್
19,
ಮಂಡೇ ಫ್ರೆಶ್ ಮಾಡಿ.
15,
ತಗೊಳ್ಳಿ. Only notice. You are accused number 2. ಡೋರ್ ಪುಷ್ ಮಾಡಿ ಗಲಾಟೆ ಮಾಡಿರೋದೆಲ್ಲ ನೀವೇ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಇದೆ ಅಲ್ಲಿ. ಒನ್ HCGP, 2 ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, ನಾಟ್ ಎ ಸಿಂಗಲ್ ಅಲಿಗೇಷನ್. ಬರುತ್ತೆ, ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಎಸ್. ನೆಕ್ಸ್ಟ್
20,
ಎಕ್ಸ್ಪ್ಲೋಸಿವ್ಸ್. ಎಸ್ ಮೇಡಮ್. ಅಡಿಷನಲ್ SPP ಬರಲಿ. ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಇಂಟರಿಮ್ ಆರ್ಡರಬಲ್ ಕೇಸ್ ಅಲ್ಲ ಇದು, ಅದಕ್ಕೆ ಆಯ್ತು. ಮಂಡೇನೆ ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ. Tag the petition along with 7-5. List on Monday. Yes. Madam, specifically date ಕೊಟ್ಟಿರೋದೆಲ್ಲ Monday ಬರ್.
21,
VC to appear. Learned Counsel Uday Prakash Mulya accepts notice for 21.1 accepts notice for the respondent, the petitioner, to serve set of papers and the said petition as well. There is no representation on behalf of the petitioner. List the matter on 21st. Yes.
22,
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲಲ್ಲ? ಆಗಿಲ್ಲ ತಾನೆ? 2, 3, 4 ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, 3, 4 ಕಾಶ್ಖಾನ್. ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಡ್.
23,
ಪಾಸ್ವರ್ಡ್. ಮೇಡಮ್, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ತಗೊಳ್ಳಿ. ಏನು ಇಲ್ಲ, ಆಲ್ ಪೊಲಿಟಿಕಲಿ ಮೋಟಿವೇಟೆಡ್ ಕಂಪ್ಲೇಂಟ್. ಪಾಸ್ವರ್ಡ್.
24,
Respondent has no capacity to pay. What is the respondent? Beautician. Dietitian 4 ಲಕ್ಷ ಏನು ಲೆಕ್ಕನೇ ಇಲ್ಲ. Dietitians are the highest earning people today. You serve a copy. Let's see. Petitioner, first time ಬರ್ತಾರ. Petitioner to serve set of papers upon the counsel who represents the respondent in the trial proceedings. List on 21st. Next date in 29th ಇದೆ ಅಲ್ವಾ? ಆಯ್ತು. 29th list the matter on 21st in the fresh matters list. Copy serve ಮಾಡಿಲ್ಲ.
25,
311. Learned counsel to the petitioner to serve set of papers upon the counsel who represents the respondent in the trial proceedings. List on 22nd in the fresh matters list. Till such time further proceedings before the concerned court shall remain stayed. Next. Judgment ಆಗಿದೆಯಾ? Judgment ಆಗಿದೆ ಅಂತಂದ್ರೆ ಆಮೇಲೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀವಿ. ಎಸ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ? 22nd entry mode extended till the next date of hearing. Disposed.
27,
Allowed, quashed. We'll send it back.
Lord, serial number 26, my lord, I pay for R4, my lord, I request not 10 days time. 26.
ಆಯ್ತು, ಅಡ್ಜನ್ ಆಗಿದೆ ಸರ್.
Please,
22nd.
please.
Yes, next. We'll post it on 22nd. We may have to allow it. We'll see. Yes, list on 22nd and the fresh matters list.
29,
2 crimes, 2 different crimes. They are different. ನೀವೇ different ಆಯ್ತು. 6 months gap. 498 ಎರಡನೇ ಸರಿ 498 ಯಾಕೆ? ಒಂದ್ಸರಿ ಆಗಿದೆ ತಾನೆ? ಮತ್ತೆ 498 will quash, but other crimes let it go on. Yes, he is also fair, accepts it. ಅಷ್ಟೇ. The petitioner is before this court calling in question registration of a crime in crime number 179 of 2023 for offences punishable under section 498A 323 504 506 of the IPC. This court, owing to the submission of the counsel for the petitioner, had granted an interim order of stay on 11/3/20 coordinate bench, 11/3/2024, which reads as follows. The interim order was granted on the score that there are 2 crimes registered in crime number 42 of 2023 and crime number 179 of 2023 on the very same cause of action and for the very same offences. The counsel for the respondent has filed his statement of objections. Counsel for the respondent has filed an application seeking vacation of the interim order, which clearly demonstrates that the first offense emerged from an act of assault on the part of the petitioner on 6/4/2023. Therefore, it became a crime in crime number 42 of 2023 for it having been registered on 7/4/2023. The second crime emerges on a further assault on 14/10/2023 by the husband. Then emerges the impugned crime in crime number 179 of 2023. Therefore, the two are not hit by the doctrine of sameness, as they are arising out of two different incidents at two different times with a gap of 6 months. The parties may be the same, the assault may be the same, but the cause of action is entirely different. One common stream that runs through both these crimes is an offense under 498A of the IPC. Section 498A of the IPC has there is no allegation in the complaint that would touch upon the offense under section 498A of the IPC for the second time all over, as it forms the offense in crime number 42 of 2023, which is already pending investigation. In that light, except 498A, all other crimes are investigatable and not and is not hit by the doctrine of sameness, except the offense under section 498A. It is right that there cannot be repeated cases of 498A being registered on the same relationship and on the same demand of dowry. Therefore, the offense under section 498A as obtaining in crime number 179 of 2024 should stand obliterated. 173 na? 123, sorry. 179 of 2023 should stand obliterated. For the aforesaid reason, the following order. The criminal petition is allowed in part. The crime number 179, the offense under 498A stands quashed. The petitioner shall be the investigation shall continue qua the other offenses. It is made clear that the findings or the observations made in the course of the order does not relate to crime number 42 of 2023 at all. Yes. Ordered according.
30,
NDPS. ಹೀಗಿದ್ರಲ್ಲ ಮಧು, ಎಸ್ ನಿಮ್ದು ಆಗೋಗಿದೆಯಲ್ಲ. ಹಾ, ವೆರಿ ಜಗದೀಶ್. ಟೋಟಲ್ 4 ಹಾಗಾದ್ರೆ ಬರ್ತಾರೆ. It may take some time. Yes. ಆಯ್ತಾ 2:30, 3:30. You come, ಕೆಲಸ ಮುಗಿಸಿ.
31,
107. ಒಂದರಲ್ಲಿ ಕೇಸ್ ಇಲ್ಲ ರಾಮಚಂದ್ರ. ಏನ್ ಅಲಿಗೇಷನ್ ಇಲ್ಲ. ಕಷ್ಟ, ನಾವು ಸುಮ್ಮನೆ ನಾವೇ ಕೊಟ್ಟಂಗ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ. You seek further investigation, then we will pass some order. ಈಗ I can't amend, one can't give you liberty. That's always open to you. But in this, after filing of charge sheet, I cannot direct amendment of the charge. Appropriate petition you should bring in. But the learned counsel for ಅದು ಯಾವುದು ರಾಮಚಂದ್ರ ಅದು 144. The learned counsel for the petitioner seeks leave of this court to withdraw the petition, reserving liberty to file an appropriate petition with regard to his grievance, as the charge sheet is already filed in the case at hand. Liberty so sought is granted. We'll see. You file it. We'll see. On the interim order subsisting shall continue till the next date of hearing. List on 22nd. Ashtal adu barli. Madi. Agata.
32,
33. Oh, 1984. Oh, this I heard in 2023. I know, yes. I remember transaction of 1985. Now you have sought money laundering in the year 2023. Act itself, post fact. I have written that black money judgment. They cannot, every act should pass muster Article 20. No, let us not spring into that at all. This itself is enough. Act itself was not there. ನಾನು ಇದು ಮುಗಿದೋಗಿದೆ ಅನ್ಕೊಂಡೆ because it's my interim order. Yes, yes. I had first case first time, First case same party. Where is the first case? ನಿಮ್ದು ಬೇರೆ, senior is there, wait. Yes. ಅದು ಆ ಕೇಸ್ ಕೊಡಿ ಮೇಡಮ್. Yes sir, 22nd 22. 85 ಆಗಿರೋ ಕ್ರೈಮ್ ನ ಇವತ್ತೇನು? even 99 ಸರ್. ಅಲ್ಲ ಆಯ್ತು, ಅಲ್ಲ even 99. 2002 is the act. Sir, 2002 is the act. Sir, Oblapuram was clarified by the Supreme Court later that it will not amount to a precedent in any other case. Pending, but there is an observation by the apex court that it will not, cannot be treated as a precedent for any other case. Am I right? No, no. I will decide it independently. Definitely decide it independently. Yes. 22nd. Is it convincible? Yes, sir. List the matter on 22nd in the. No, that I remember. The Amanat Bank talva. Yes. Alla, PMLL, all right. If money trail connection to the accused early, that we'll see. That is also because unless you allege conspiracy, you cannot drag in that also. That is Pavana Dibur Supreme Court judgment. ಯಾವ್ದ್ರಲ್ಲಿ ಇವ್ರದ್ರಲ್ಲಿ ಅವ್ರು ಬೇರೆ ಸೇಮ್ ಪಾರ್ಟಿ ಇಸ್ ದಿ ಸೇಮ್ ಅಸಾದುಲ್ಲಾ. ನೀವ್ ಯಾರಿಗೆ ಸರ್? ಹೌದು, ಅವ್ರ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಆದ್ರೆ ಇವ್ರಿಗೆ ಏನ್ ಸಂಬಂಧ? ಸರ್, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಸೀನಿಯರ್ ಅಪಿಯರ್ ಆಗೋ ಮ್ಯಾಟರ್ ಇಟ್ಸ್ ರೆಹಮಾನ್ ಖಾನ್. ಎಸ್, ದಟ್ ಈಸ್ ರೆಹಮಾನ್ ಖಾನ್. ಅದು ಕೊಡಿ ಮೇಡಮ್. No, this I vividly remember having granted an interim order. 29/5/23. 1985, see, a transaction of 1985 up to 2022 is complained of on 29/5/2023. Act came into effect on 17/9/2005. 99 ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಅದೇ 85 to 2002. No, it's PMLA 2002, but it came into effect on 17/9/2005. What point? ಯಾವ ಕೇಸಲ್ಲಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಯಾವ ಕೇಸಲ್ಲಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ? Not as a precedent in any case. In any case. No, that is by the division bench, sir. That is stayed. A stay admele, you started giving retrospective effect to every case. That is why Supreme Court clarified, don't treat this order or that order as a precedent in any case. I will pass. Either bitre, 85, 80 lella money laundering agide anta you will go on. This is exactly what was done in that Black Money Act judgment. Now, we have not seen that, sir. That's a very detailed order I have passed. Yes, Black Money Act interpret ಮಾಡಿ. Their acts of 2007 and 2008 were sought to be made offences of the act coming in 2015, as it is unconstitutional. ಯಾವಾಗ? No, if this is permitted, then it will have a chilling effect. Yes. Yes. Interim order heard the learned senior counsel C.V. Nagesh appearing for the petitioner. The learned counsel Jaikar Shetty seeks objections ಹಾಕಿದ್ದೀರಾ? The learned counsel Jaikar Shetty ಇದೇ connect ಆಗಿದೆ? Yes, learned counsel Jaikar Shetty submits that he would make his submissions on the next date of hearing. List the matter on 22nd in the fresh matters list. First ಅಲ್ಲಿ notice ಆಗಿಲ್ವಾ? Learned ನೀವೇ ತಗೊಳ್ಳಿದ್ರು. Learned counsel Jaikar Shetty is directed to accept notice for the respondent registry to print the name of so and so as appearing for the respondent, petitioner to serve set of papers upon the aforesaid counsel. List on 22nd. You are accused number 1, no stay. We'll see. Yes. ಇದ್ರ ಜೊತೆಗ ನೀವ್ಯಾವ ಅಕ್ಯೂಸ್ಡ್? ವಿಚ್ ಅಕ್ಯೂಸ್ಡ್? ಅಕ್ಯೂಸ್ ನಂಬರ್ ಹೇಳಿ ಸರ್. ಅದು ಒಂದು ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಉತ್ತರ ಕೊಡ್ತಾ ಇದ್ದೀರಾ. Tag this petition along with source. Same day. Yes.
33,
Settled, Delhi Hegde or pass over.
34,
Provisional degree certificate. ಇರೋದು ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೇಳಿದೆ ನಾನು. ಕೊಡಿ. ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಅಲ್ಲ ಕೇಳಿದ್ದು, ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್. ಅರೆ ಒಂದೊಂದಾಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಯಾಕೆ? ಪ್ರೊಡಕ್ಷನ್ ಇದೆಯೋ ಅಥವಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಯಾರು ಕೇಳಿದ್ರು ಸರ್? ಯು ಕಮ್ ಔಟ್ ವಿತ್ ಫ್ಲೈಯಿಂಗ್ ಕಲರ್ಸ್. ಪರವಾಗಿಲ್ಲ, ಬಟ್ ವೇರ್ ಇಸ್ ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್? The learned counsel for the petitioner places on record the statement of marks of the petitioner to demonstrate that he has passed ಯಾವುದಿದು homeopathy, so and so homeopathy, and would seek time to place the degree certificate on record as it is under production. Sorry, seeks time to place degree certificate on record. Yes, ಅದು ಗೊತ್ತು. Yes, all right, good. ಯಾವತ್ತು? 20. List on 20th in the fresh matters. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ಹೋಗಿ. ನೀವು ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ ಒಟ್ಟಿಗೆ ತಗೊಂಡೋಕೆ ಇಲ್ಲೂ ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಆಲ್ ರೈಟ್, ಆಲ್ ರೈಟ್.
The complainant matter is a person who is claiming ownership by a hospital. Legal notice issue ಮಾಡ್ತಾರೆ. Legal reply ಅದರ ನಂತರ police complaint ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿ originally complaint ಬಂದ್ಬಿಟ್ಟು I made doctor ಅಂದ್ರೆ certificate produce ಮಾಡ್ತಾರೆ.
Correct.
ಆಮೇಲೆ ಇರ್ತಾರೆ further joint owners ಅಂತ. Then I produce the registration certificate of the hospital to show I am the only owner.
You asked your petitioner what is the concept of homeopathy. Fake doctor ಅಲ್ವಾ ಅಂತ ಗೊತ್ತಾಗಕ್ಕೆ. But you are a homeopath. Why you are not treating? If you are a homeopath, you should treat. Business.
Treatment patients at the owner of the hospital. The complainant claims CS of the investment circle amount. He is also joint owner of the hospital. So issue me a legal notice say you should.
All right, you produce everything. List on 29th. Till such time, no precipitative action shall be taken against the petitioner, or in the garb of investigation be harassed. Yes. In a soft karita. Yes.
35,
NBW. ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಸರ್. ಆನ್ ಮಾಡಿ.
I'm sorry.
ವೈ ಪ್ರೊಕ್ಲಮೇಶನ್.
My lord, he was not appearing. He was absconding all the way through the trial.
ಅಪಿಯರ್ ಸರ್.
My lord, I am for the complainant. My lord, I am seeking
Oh, the
execution of NBW.
implementation, correct. Yes, madam, I asked you on the last occasion. Why? ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಪಾಸ್ ಓವರ್.
Grateful.
Ilder will issue proclamation
36.
if Jagdish does not appear. Yes.
My lordship.
My lordship, corrected matter there.
ಗೊತ್ತು.
Allegations for 354 and 354D, my lordship.
ಹ್ಮ್.
We are the neighbors. And baseless allegation 3 years ಮುಂಚೆ ಏನಾಗಿದೆ ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. And ನಾನ್ ನೈಬರ್ ಆಗಿ just came to home. ಅವರೇ ಬಂದ ಮೇಲೆ
ನಿಮ್ಮ ಮೇಲೆ
ರಕ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ my lordship.
ಆ?
ರಕ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. They started to fight.
ಅವರೇ ಬಂದು ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
My lordship, unnecessary issues ಮಾಡ್ತಿದ್ದಾರೆ.
Unnecessary issues.
Yes, my lordship. Baseless allegations from past 3 years, just to vacate me from this place.
You have vacated the premises now?
No, my lordship.
ಯಾಕೆ ಅಲ್ಲೇ ಇದ್ದೀರಾ?
Own house, my lordship.
Own house?
Yes, my lordship.
Why you are to be vacated?
My lordship, as per their allegations, I had a relationship with our daughter. My lordship, I am a
That's the
retired army
allegation, sir.
person. I am a
That's
retired
the
army. person.
allegation.
Yes, my lordship.
ಅದಕ್ಕೆ
3 years,
354D ಇರೋದು.
3 years back, my lordship.
No, you continuing that even today.
No, my lordship.
You are not vacated.
She's in London, my lordship.
She has gone to London now.
Yes, my lordship. Victim complaint ಕೊಟ್ಟಿಲ್ಲ, my lord.
Not London,
Vic-
Malta, I guess. Yes.
She has been, her mother has been raised a complaint and
Hmm.
3 years baseless allegations.
Baseless
I'm a retired army person. I'm saving my money and own house ತಗೊಂಡಿದ್ದೀನಿ. I'm settled.
Retired army.
Yes, my lordship.
ನಿಮ್ಮ ವಯಸ್ಸು 43.
Yes, my
5 ವರ್ಷ
lordship.
ಇದ್ರಾ?
Sorry.
5 years ಇದ್ರ ಆರ್ಮಿಲಿ?
Yes, my lordship. A baseless allegation, 3 years baseless allegation, my lordship.
Yes, madam.
My lordship, allegations are there in the complaint, my lordship, and even if he's threatening now also when she is in the London, my lordship.
Yes. 1 HCGP 2 emergent notice.
My lordship,
ಎರಡು-
kindly stay there.
ಆ,
Other accused 2 ಇದೆ, my lordship.
accused ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
Accused 2, my lordship. ನನ್ನ ತಮ್ಮ, my lordship.
Accused number. There shall be an interim order of stay only against accused number 2
My lordship, kindly look at page number 18, my lordship.
till the next date of hearing. 1 HCGP 2 emergent notice. Next.
37.
But 447 and 448 is covered by your lordship's order.
Interim order ಇಲ್ವಾ?
Illa, sir. It came up on Monday, your lordship said directed the prosecution to produce the.
Who's in possession, I asked,
My lord, we are in possession. And as per this honorable court's order itself.
in the meantime. Next.
Grateful.
1 HCGP 2 emergent. Next.
38.
Appearing for the petition in this case, my lords. My lords, before the trial court, the matter is listed on 12/8, my lords, for orders.
ಆರ್ಡರ್ಸ್ ಹೋಗಿದೆ
Stay ಮಾಡಿದಿಲ್ಲ ಸರ್?
ಅಲ್ಲ ಆರ್ಡರ್ಸ್ ಹೋಗಿದೆ ಅದಕ್ಕೆ
ಏನು
ಬೇಲ್ ಆರ್ಡರ್ಸ್ ಲಾರ್ಡ್ಶಿಪ್ ದೇ ಹ್ಯಾವ್ ಕಮ್
Bail
ಹೌದು
Bail orders.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
ಆಯ್ತು, list on 13th.
Please.
13th fresh matters list.
Please.
Next. Oh, ಇದು.
The interim
Not
bail
to
granted,
arrest.
my lords.
Not to arrest.
they had intention to settle the matter in police station.
Let's see.
They have
Yes.
filed a subsequently
13th,
2
13th.
application, 2 FIRs.
Yes.
39.
Freezing.
Freezing.
I may be permitted to file wakalat on behalf of R2. File detailed objections.
Detailed objections. Why?
Lord, they are challenging the crime number registered in the Vijaypur district. And relying upon the.
Account ಎಲ್ಲಿರೋದು? ಯಾವ ಬ್ಯಾಂಕ್?
Sahakar Nagar,
ಹಾ.
Bombay, Sahakar Nagar in Bombay.
ನಿಮ್ ಇದ್ರಲ್ಲೇನ ನಿಮ್ ಅಪೇರ್ ಆಗ್ತಿರೋ?
But my lord, they are relying upon the judgment, my lord.
But
passed
I'll
by
just
the
pass on
Kalburgi
the
bench.
details of these accounts.
In a check bounce case, they have quashed the case, my lord.
Oh.
He is an accused number 2 in the check bounce case. This is 420 case, my lord. This is separately registered.
After check bounce.
Yes,
Yes.
after check bounds, my lords, I
1 crore 26 lakh.
1 minute. What happened to the 138 proceedings?
it's quashed. Vis-a-vis, my
Apart
lords,
from
it's-
A1, my lord, other accused persons have been quashed.
It's quashed.
Their
Which
case is
accused are you?
Because I was A2 there. So
For a moment, A2 in the check box. I'm sorry, A4 minutes, running page 26.
138 number ಹೇಳಿ.
Minutes, criminal petition.
Criminal petition ಅಲ್ಲ, crime, CC
Minutes, 2761 of 22.
2761 of
22. Baswan Bhagya.
quashed.
Minutes, quashed minutes in 200733 2023.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Running page 26. minutes.
200733 of 23
Please.
dated
Minutes, 10/10/2023.
10/10 should be
Yes.
my order then.
Yes. Minutes,
Justice Venkatesh Naik.
Oh, ಇದು ಗುಲ್ಬರ್ಗ. Yes.
Gulbarga.
Yes.
Consequent upon which minutes, one more FIR is registered, minutes, this time
For
not against
420.
minutes,
For 420.
420, it's not against me. Kindly see minutes, it's not against me. It's
You were
registered,
accused number 2 there.
because I was accused number 4 in the,
138 proceeding
yes,
accused number.
minutes, I accused number 5. Then minutes,
Correct
then
ಆಗಿ
minutes
ಹೇಳಿ.
here, minutes, I am not an accused. My father is made an accused.
Asking you ಅದರಲ್ಲಿ ಯಾವ accused ಅಂತ?
5.
Accused number 5.
Please.
In which, in that one? In this, your father is the accused.
In this minutes, my father is the accused. My accounts are sought to be fixed.
Your father is accused number.
Sole accused,
Sole accused, huh?
sole accused, sole accused. Sole accused here.
He was accused number what in that proceeding?
Minutes, there minutes, he was accused number 3.
A3.
A3 minutes.
Yes, sir.
Miller, kindly,
We'll grant you.
Sir, the copy.
We'll grant you times.
Please.
Heard the learned counsel appearing for the, Sunil Rao appearing for the petitioner. The petitioner in the present case is the sole accused.
No,
Fi-
I'm not even the accused.
Oh, the petitioner in the case at hand is knocking at the doors of this court for a direction to defreeze the accounts of the petitioner. The case has a little history. The present complainant had instituted proceedings in proceedings against the father of father
Father, not sir.
against the
Father,
present
mother.
against the present petitioner and others. The
And-
present petitioner was A3 in the said proceeding for offence punishable under section 138 of the Negotiable Instruments Act. The proceedings were sought to be tried in CC 2671 of 2022. The bench at Kalburgi, they quashes the proceedings in criminal petition 200733 of 23 in terms of its order dated 10/10/23. The said order is said to have become final today. After the quashment of the order, after quashment of the proceedings in the aforesaid order, comes the impugned crime for offences punishable under section 420 of the IPC. The registration of the crime itself is doubtable, as the apex court in the case of so and so in 2022 SSC online SC 111010 has referred the matter to a larger bench as to whether a crime under 420 would become maintainable either simultaneously or after the closure of the proceedings under 138 of the Negotiable Instruments Act. Be that as it may, the present petitioner is not the accused even in the impugned crime. It is his father, and the account of the petitioner is sought to be frozen. In the light of the aforesaid circumstance, stay ಕೇಳಿದಿರಾ?
Yes, please.
Huh?
Yes, please.
In the light of the aforesaid circumstance, there
If
shall
we-
be an interim order of stay as spread for. The learned counsel for the respondent complainant is at liberty to seek variation of the interim order on filing his objections or otherwise. List the matter on 29th in the fresh matters.
Only one interim. It was accused number 5, not 3 minutes.
ಅದರಲ್ಲಿ
Accused number 5.
in the CC
Yes, please. Accused number 5.
A5 ಅಂತ.
If.
Yes. Yes. Madam. Withdrawal ಮುಗಿಸ್ಕೊಂಡ.
Orders 40.
My lord, I beg to appear for the petitioner in this matter. Petitioner is accused number 3, challenging the proceedings wherein charges.
CW2 is no, complainant is no more?
My lord, complainant is an official witness, for which reason
Official
yes, coordinate bench thought that anybody who's a next of kin has to be ordered notice to. Father is no more, my lord. Mother is served.
Yes. We'll list it after 2 weeks, yes.
My lord, there is no interim order, my lord. Hence, I've moved
In
this.
special court matter ಇದು.
No, my lord. The offense is only 3
All
not 2,
right, list on 21st
please.
in the fresh matters list, yes.
please.
41 to 45, all in terms of the memo withdrawn.
Forty-six.
Orders ಮುಗಿಸ್ಬೋಣ. Office objections raised in objection so and so. Resolution of marriage. Settlement.
Settlement.
Huh?
Settlement, no objection ಹಾಕಿದ್ದಾರೆ.
2:30 thought. Close ಮಾಡಿ.
Please,
ಅಲ್ಲಿ no objection ಹಾಕಿದ್ರೆ parties are not present.
parties are present here.
Then what? ಕೊಡಿ.
Father, first petitioner is not present. He in
Accused is
Germany.
not present.
Yeah, her husband.
First accused. He is in Germany.
ಈಗ who is, where is the settlement?
Between the second respondent and the.
Where is the
in-
settlement?
in Kula has been given by the.
ಎಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ವಾ? ಕುಲ ಅಂದ್ರೆ ಕುಲಾನಾಮ
Has
ಎಲ್ಲಿ?
been placed before the court.
When?
Last date of hearing.
ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲ?
Filed in August 1st, your lordship.
Password. Where is the kulanama? Yes,
Yes, I will go for this.
47.
Forty-seven.
In compounding,
6 of the POCSO Act, please.
password.
Please.
48.
Non-compliance of office.
For
subject-
petitioner, so batch matters ಎಲ್ಲ dispose ಆಗಿದೆ, ಒಂದು ಮಾತ್ರ pending ಇದೆ.
ಯಾವ್ದು ಕೊಡಿ? ಯಾವ್ದು ಮೇಡಮ್? ಓ ದಿಶಾ ಚೌಧರಿ ಇದು. ಆಯ್ತು, ಡಿಸ್ಪೋಸ್ಡ್. ಇದು AV ಇದು. ಎಸ್, ದಿಶಾ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಡಿ.
Forty-nine.
ಮೇಡಮ್ ಅಪಿಯರೆನ್ಸ್ 12/8 ಕೊಡಕ್ ಹೋಗ್ಬೇಡಿ. 19/8 ಕೊಡಿ. ಅಥವಾ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ನೆಕ್ಸ್ಟ್ ಎನ್ಸೂಯಿಂಗ್ ಡೇಟ್ ಅಂತ ಮಾಡ್ಬೇಡಿ.
49.
2 weeks time to do the needful.
50.
Interim ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. 50. Yes. Objections?
Lords, they have filed the objections, my lords.
There's some office objections in the objections.
The objections. But I've spoken to my senior counterpart. We'll somehow try to settle this issue. Husband and wife.
Husband and wife.
14 ಕೇಸ್ ಆಗಿದೆ ಈಗಾಗಲೇ.
14 ಕೇಸ್ ಆಗಿದೆ.
Now, Honorable Court itself, 14 CRPs, criminal petitions.
I have dismissed.
I have produced, my lord. Yes, all his petitions which were filed are dismissed.
The question here, my lords, is the quantum of alimony. That
Of
apart,
course, here, my lord,
we'll try for a substantive settlement.
ಸೆಟ್ಲ್ ಆಗೋಂಗಿದ್ರೆ ಮಾಡ್ಲಿ.
the present petition is filed. Again, the interim order rejecting his application for stay, that's all.
All right.
And he has not even.
No, if you want to settle it, last chance I will give.
ಅದನ್ನ ನಾನು ಮತ್ತೆ ಹೇಳಿದ್ದೀನಿ ಅವರಿಗೆ.
ಇಲ್ಲ ಅಂದ್ರೆ we'll close it on 21st. List on 21st in the
Because
fresh
even
matters list.
Last time, my lord said the interim order entered earlier in the trial court should be paid that amount, that is 10,000 per month. Even that is
ಅದು
not.
continue ಮಾಡ್ತಾರೆ.
ಕಟ್ಟಿದೀವಿ.
Okay,
But I have the memo with details. In fact, I furnished a copy on my learned senior counterpart.
Next time, if I find that no maintenance is paid,
ಕಟ್ಟಿದೆ.
I will enhance the maintenance.
Very well.
Yes.
Great.
List on 21st.
Very well.
Please.
51.
Needful time, my lord. Section
And at cancel for the petitioner submits needful has been done. List on 13th September. ಅದೇ ಸೇಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಂಗಿಲ್ಲ, ಅದೇ ಆರ್ಡರ್ ಮೇಡಮ್. 7A order. Yes.
52.
POCSO matter, madam, which is today.
POCSO,
POCSO matter, madam. The affidavit is ready for parties.
14 years.
ಅಲ್ಲ ಇದು 16 years. 16 years. So ಅಲ್ಲ ಈಗ 1 month ಇದೆ 18 years.
Password. 53 Axis Bank, same order.
10 days time may be granted.
Huh?
Office objections ಇದೆ, 10 days maybe.
We'll dispose it. Same order, right?
Yes, ma'am.
Same order, Axis Bank office.
Good.
Next.
54.
Respondent, please.
Post immediately after service of notice.
The
upon
matter has
the-
been settled.
Settled.
Please.
In offense.
498.
That's all. Where is it?
Monday,
Monday, but Tuesday.
please.
List on Tuesday, 2:30 PM to report settlement.
55.
For the petitioner, my lord, sir. I'm ready to deposit, time may be granted, my lord, sir. Maintenance amount.
ಎಷ್ಟಿದೆ? ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿತ್ತಾನೆ?
Yes, my lord.
4 ಲಕ್ಷ arrears ಇದೆ ಅಂತ
Yes,
ಹೇಳಿದ್ರೆ
yes,
ನೆನ್ನೆ.
madam.
2 lakhs DD ತರಕ್ ಹೇಳಿದೆ. Where is the DD?
My lord, sir, that's why I seeking some time, my lord, sir. Within time may be fixed, my lord, sir, I will ready. My lord, sir, due to
4 lakhs ಕೊಡೋವರೆಗೂ ಓಡಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಆರಾಮಾಗಿ?
maintenance pay ಮಾಡ್ತಾ ಇದ್ದಾರೆ some regular ಆಗಿ, but
ಮೇಂಟೆನೆನ್ಸ್ ಪೇ ಮಾಡಿದ್ರೆ arrears ಯಾಕೆ ಬರುತ್ತೆ ಸರ್?
ಅಂದ್ರೆ full amount ಕಟ್ಟಿಲ್ಲ.
ನೋ ಸರ್. ಏನು ಅಲ್ಲೂ ಬಾರ್ಗೇನ್?
ಅಲ್ಲ ಒಂದು 3 weeks time may be granted, my lord, sir.
I'll grant you 2 weeks time. Deposit 2 lakhs. Otherwise, interim order would automatically vacate,
3
get
weeks.
vacated.
One,
The-
3 weeks.
There shall be an interim order, learned counsel for the petitioner submits. The arrears as on today is at 4 lakhs.
my lord.
Therefore, the petitioner shall deposit 2 lakhs before this court by in the next 3 weeks.
4,84,600.
Barkumbudi madam, correct, 4,84,000. So 50% of that, 50% of the amount in the next 3 weeks. List the matter on 5th September in the fresh matters list. In the event the petitioner would not deposit the amount by the next date of hearing, the interim order would not only get vacated, the petition also would be dismissed. Yes.
Within office objection, I will comply with him.
By office objections, we complied in the meantime, emergent notice to the respondent,
Please.
returnable by the said date. Next.
56,
This matter pertaining to Lodha committee, my lordship.
Ah,
My lordship, serial
ಇನ್ನು
number
ಎರಡು ಮೂರು ಆಮೇಲೆ ಇದೆಯಲ್ಲ.
please 75 ಅಲ್ಲಿ ಇದೆ. Same parties complaint ಅದ್ರೊಳಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು, ಆ ವಕಾಲತ್ ಹಾಕಿದಾರ ಅಲ್ಲಿ?
ಹಾಕಿದ್ದಾರೆ ಅದ್ರೊಳಗೆ.
ಯಾರಿಗೆ ಹಾಕಿದ್ದಾರೆ? ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಆ, ಇಲ್ಲಿ
ಆ ಮ್ಯಾಟರ್ ಬಂದಾಗ ಹೇಳಿ.
Please.
ಪಾಸ್ವರ್ಡ್ ಇದು 56 ನಂಬರ್ ಹೇಳಿದೆ.
75 connect.
Tag this petition along with 75.
And yesterday also 2 matters came.
ಹಾ,
Yesterday order to connect with this matter there and today has to be listed, but it has
ಅದೇ
not.
ಅದ್ಯಾವ್ದು ಮ್ಯಾಟರ್ಗಳೆರಡು?
I believe.
ನೆನ್ನೆದೆಲ್ಲ ಆಗಿಲ್ಲ. We'll tag everything
Please.
and list them all on 21st.
Grateful much.
Yes. ನೆನ್ನೆದ ಎರಡು ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. List them all on 21st. Petitioner shall serve on the counsel who represents the respondent in the, lunch. Respondent in the,
75 serial number.
respondent, ಅದು ಯಾರು ಆಗಿದ್ದಾರೆ ನೋಡಿ ಮೇಡಮ್. Gautam Bharadwaj. So Gautam Bharadwaj is directed to accept notice for the respondent. Yes.
Great.
Tag them all. 4, 5 ಇದೆಯಲ್ಲ ಅದು?
5 ಇದೆ.
5. ಎಲ್ಲ ನಂಬರ್ಸ್ ಕೊಡಿ. 21st. Yes.
Grateful.
ಮೇಡಮ್ ಲಂಚ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಲಂಚ್ ಇದೆ ಮತ್ತೆ. ಇಲ್ಲ 3 ಮ್ಯಾಟರ್
Under 498, my lords.
For the.
57.
Please, my lords. Offense under 498, 506, my lords.
Vacating stay.
Please.
I filed for the.
Then we'll hear it afternoon. Yes.
Please, great.
63 may I request Tuesday.
30?
63 my lord.
Yes sir. ಏನ್ ಬೇಕು?
Tuesday ma'am.
ಮೇಡಮ್ ಯಾರ್ಯಾರು ಟೈಮ್ ಬೇಕು ಕೊಟ್ಬಿಡಿ.
58, my lord.
Taken along with 77, both are heard and for dictating orders.
I am not dictating any order today, sir. Yes.
Serial number 58, my lord.
Court officer 63 Tuesday. Court officer.
Madam, 92. 92.
63 madam, Tuesday. ಹೋಗಿ ಪೆಟ್ರೋಲ್ ಹಾಕಿಸ್ಕೊಂಡ್ ಬರ್ದಂಗ Tuesday.
Hello, court officer? Court officer? Court officer?
under section 376, my lords.
Huh.
I was about to fly to Singapore, my lords. My passport came to impound, my lords.
Huh.
Here, my lords, the facts, my lords, is to promise marriage, my lords.
ಬೆಳಗ್ಗೆ you moved the memo.
That is, we had a anticipatory bail in that case, my lords. In this case, my lords, this is a fresh matter, my lords. Monday, my lords.
Monday.
Grateful.
311 application lordships recollects the flight expenses ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ lordship. That witness, my lord, we could not secure the witness for the cross examination.
Dubai ಇಂದ.
Dubai.
Ah.
Adರಲ್ಲಿ that whole trial is halted, my lord, for want of that 311 application. Lordships may have it anytime next week, my lord. Otherwise, the whole trial is
Alright,
halted.
ಅದನ್ನ let's sit on
Very short.
next week.
Any date convenient.
21st. 21st.
Matter, my lord. Bless.
The respondent number 2, who is the subsequent purchaser of the same property, has registered the FIR against me. I am the first purchaser.
All
The
right.
GPA holder of developer has sold the property to the respondent number 2.
ಆಯ್ತು.
After lapse of 6
20th
years-
ಬರ್ತ್ 20th ಕೊಡಿ.
But kind hammers Monday, my lord.
No,
Fresh matter, my lord.
Monday full ಆಗಿದೆ.
Withdrawal.
When do you want, madam?
That's end of the list.
End of the list? Give it.
Serial number 9, my lord. It is posted on 21st, my lord. Connected matters to the 311 application.
ನೀವು ಇರ್ಲೇ ಇಲ್ಲ. ಮತ್ತೆ?
Apologies.
You are not there.
I was not there. Apologies.
Let's see. When is it listed?
21st, it is listed, my lord,
Okay.
connected matters, my lord. All three trial, my lord, is stayed on 311.
I told him.
My lord, fresh matter memos. Memo.
Why? Morning you were in some other court.
I didn't know that, my lord.
Huh? Yes, no. One urgency. Tell me the urgency.
There's no urgency.
No urgency. No urgency ಗೂ ಮೆಮೊ ಮಾಡ್ತಾರ. Yes. Sign back, madam. Sign.
Lordship, may I mention, lordship?
My lord, this is emergency, man.
Huh?
Daughter's marriage is there.
What?
My daughter's marriage is there.
Daughter's marriage.
Yes.
What has happened now?
And the check is bounced.
Huh?
Check bounce ಆಗಿರೋದಕ್ಕೋಸ್ಕರ 4 lakhs ಗೆ ಇದ್ ಮಾಡಿದ್ದೆ.
ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿರೋದಕ್ಕೆ ನಿಮ್ ಡಾಟರ್ ಮ್ಯಾರೇಜ್ಗೆ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ ಈಗ ಆಕ್ಚುಲಿ ಏನಾಗಿದೆ ಇದು ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದೆ ಇದು.
ಹಾ.
ಟೋಟಲಿ
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್?
ನಾನು ರೆಸ್ಪಾನ್ಸ್ ಸೈಡ್. ಅದಕ್ಕೆ ಸ್ಟೇ ವೆಕೇಟ್ ಆಗೋದಕ್ಕೋಸ್ಕರ.
ಸ್ಟೇ ವೆಕೇಟ್ ಆಗ್ಬೇಕು. ಕೊಡಿ. 21 ಮೇಲೆ.
ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಎಸ್ ಆಯ್ತು.
My lord, 482, fresh matter.
ಯಾಕೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದೀರಿ ಈಗ? ಅರ್ಜೆನ್ಸಿ ಏನು?
My lord, proceedings HBC ಇದೆ.
ಹಾ, ಅದಕ್ಕೆ?
Interim.
Yeah, next week, yes. Yeah, that council. Yes.
Lordship, would recall that Lordship had passed an order in a child custody matter. In
Which
that
is
case,
this custody.
yes, a child custody matter, Lordship. In fact, what
Duty.
happened that
School at duty, is it?
no, not that. School
Alright,
in
what
duty,
is
it
it?
was a school in Bangalore.
What's the
itself.
problem now?
When the mother was not giving,
Huh?
the problem now is Lordship had passed the order of shifting. The problem now is that the Lordship had passed an order that the custody should shift for 1 month. Mother has not complied. Thereafter, the matter went to the contempt court and to the Supreme Court. Supreme Court was pleased to set aside the order of the Honorable High Court. But Lordship, we now back to your Lordship for clarification on the order. Because
Sorry?
there was no, we are back to your Lordship to clarify the order to the extent
Why
that
Supreme Court, if Supreme Court has set it aside, there is no order at all.
No, Lordship. Lordship's order has not been set aside.
Then,
Lordship order still stands, but because your Lordship order was not being complied with, we filed the contempt before the High Court. And in the High Court, the child was spoken to and nobody else was heard, and the order was passed. We assailed that order before the Supreme Court. Supreme Court said none of these observations will be taken into account in the other contempts pending before the family court. But now, in the peculiar situation, Lordship, that the order is still valid, but it's not being complied. So, Lordship, we want to move an IA for clarification that why shouldn't the custody shift immediately, because the mother never gave it for 1 month when it was required.
all right, well, take it on 21st.
I'm so grateful. And in fact,
Yes.
we had moved it before another court by mistake, and it was allowed for 6th of this month. But now, Lordship, we are in
All
your
right,
hand.
all right, all right, yes.
21st. I'm so grateful, Lordship.
21st, yes.
I'm so grateful, Lordship. Thank you.
Your Lordship, if I may be permitted, there's one memo for posting the matter has been settled between the parties, Your Lordship,
When do you want?
on 14th, Your Lordship.
13th? 13th,
And one memo, an IA for vacating stay has been filed.
that is next week, yes.
Grateful. Lord.
Yes. Pronouncement. ಸಿಗ್ನೇಚರ್ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲಿಲ್ವಾ? 63 ಅರ್ಜೆಂಟ್ ಮಾಡಿಲ್ಲ.
2 weeks ಅಂತ madam.
ಹಾ.
2 weeks ಬೇಡ ಅಂತ that's what I want. Tuesday, if possible, Tuesday. madam.
Wait, we'll call it, yes.
Please, madam.
Pronouncement.
Number 2, pronouncement of order. Bill number 1.
Criminal petitions preferred by accused number 1 to 6, 8 and 12. In criminal petition 4476 of 6 and connected cases are allowed. Crime registered in crime number 278 against those accused stand quashed. Criminal petition preferred by accused number 7 in criminal petition 3289 of 2023 is rejected. Interim order, if any, operating in favor of accused number 7 stands dissolved. Further investigation shall continue against accused number 7. It is open to accused number 7 to knock at the doors of the appropriate fora once investigation gets concluded for appropriate relief. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the case of the petitioners under 48 of the CRPC, which will not bind or influence a pending proceeding before the concerned court against accused number 7.
I'm grateful.
Bill number 2.
Dismissed.
Number 3.
Much obliged, my lords.
Dismissed.
Number 4.
This I'll lay down certain guidelines. Criminal petition is allowed. Notice dated 8/12/2023 issued by the first respondent stands obliterated. Also, all consequential actions, including registration of the criminal case, also stands quashed. The state shall issue a notice within 1 week from the date of receipt of the copy of the order. The petitioner shall submit a reply within 1 week after the receipt of the said notice. Thereafter, the state is at liberty to initiate action strictly in consonance with Section 20 of the Act if need arises, bearing in mind the guidelines so extracted in the course of the order. And after submission of the reply, Act if need arises, the petitioners are entitled to all consequential benefits that would flow from the quashment of the notice and all actions taken thereto. A copy of this order shall be transmitted to the Secretary, Health and Family Welfare, Government of Karnataka for necessary compliance. I've given you liberty in terms of what I've observed. Nimdu agutte, same word, will pass, wait. Yes. Avrdu alone madbek, because application, there is a deeming provision under Section 7.
Doesn't apply, I'll explain not applicable.
All right, we'll see, yes. Your scanning machine has a problem. That's why ಆಗ್ತಾನೆ ಇಲ್ಲ.
Make a submission.
Yes.
Correspondence.
Dismissed.
Grateful.
This petitioner does not deserve anything. District court ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇಲ್ಲಿ ಏನು ಹೇಳ್ದೇನೆ ಹಾಕಿದ್ದೀರಾ,
ಕ್ಲೋಸ್ ಆಗಿದೆ ಸರ್.
ಏನ್ ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ, ಇವತ್ತಿಗೂ ಪೆಂಡಿಂಗ್ ಇದೆ. Even then I have allowed it because voluntary statement,
ಎಸ್
allowed cost. ಅದಕ್ಕೆ ಪೆಟಿಷನ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಸಪ್ರೆಸ್ ಮಾಡಬಾರ್ದು ಏನು.
ಕ್ಲೋಸ್ ಆಗಿದೆ ರಿವಿಷನ್.
ನಿಮಗೆ ನಾನೇ ಕೊಡ್ತೀನಿ. ಎಸ್,
Petitions.
dismissed.
8,
Writ petition is allowed. Proceedings in special CC 850 of 2018 pending before so and so stands quashed. It is made clear observation so and so will not become applicable to any other accused. And madam? ಆಮೇಲೆ ಮುಗಿದು I'll manage, but manage. Madam. Yes. ಬೇಡ ಆಮೇಲೆ ಮುಗಿಸ್ಕೊಂಡು ಇಷ್ಟು ಕಂಟಿನ್ಯೂ.
continue. Please, 7.
Yeah, for the respondent, Lords, I'm being led by Senior Counsel Madam Jaina. She's requested the matter to be taken up at Madam Jaina Kotari, madam.
This is a matter where 8 proceedings between the parties.
Be taken up at 4 PM, my lords. She's on her legs.
I've heard you. I think you have to reply.
No, we have to start, my lords. My lords,
ಮತ್ತೆ eight cases ಅಂದ್ರೆ?
Every time the matter came up, my lords, we had pointed out there are 8 proceedings between the parties. And so far as criminal proceedings are concerned, we have given a complaint against them, which is stayed, and they have given a complaint against us, which is stayed. The one that they have given is 498A and 506, my lords.
My lords, the FIR, my lords, reads 498A and 506, my lords. I have just produced a memo, my lords, wherein the chats between the
Then
petitioner.
I will commence, my lords. I'll commence to the whole.
My lords, that is why it may be heard at 4 PM.
I don't know whether I would be able to take it. Anyway, pass over.
Pass.
Yes. Yes.
TA,
Await service. Notice await.
Post immediately after service of notice upon the second respondent. Interim order, yeah?
ಇಲ್ಲ.
Yes. Same order, entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. ಇದೆಯಾ?
ಇದೆ ಸರ್.
please, hearing on 9.
60, my lord, it's connected with 77. Both were heard by your lordship. And both had to be 77 posted
Yes,
for
Kirtana
judgment.
madam.
My lord, I appear for the petitioner in serial number 60.
ನೀವು appear ಆಗ್ತಿದ್ದೀರಾ?
Oh, I'm appearing.
60.
60 and 77. In fact, both the matters.
ಮತ್ತೆ ನೀವೆಲ್ಲಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ನಾನಿದ್ದೀನಿ ಸರ್. Respondent.
No.
ಕಡೆಗೆ.
BM
TGMC
ಮಡಿಗ.
Bank. TGMC Bank.
ನೀವು BM ಮಡಿಗ.
ಹೌದು ಸರ್.
ಹಾ ಸರ್.
The two matters also 60 and 77, my lords. In fact, we have the synopsis prepared for the
Then
entire matter.
77 ಬಂದಾಗ ತಗೊಂತೀನಿ.
Please.
Both I'll take. Yes. Compounding offense. Poxona. ಏನ್ ಮಾಡೋದಿದೆಲ್ಲ ಹೇಳಿ?
There are some.
There
my
are a
lord, where
few.
There is a border
ಇಲ್ಲ
cases.
ಎಲ್ಲದ್ರಲ್ಲೂ 17 years 11 months 17 years 8 months
Yes.
ಅಂತಾದಿದ್ರೆ
Yes,
tell
one,
me this below 16 years
one issue, my lord, there are some,
below 16 ಅಲ್ಲ below 16.5 17 ಅಂತ
yeah, and one Child Marriage Act
ಹಾ
where parents have.
parents will have to be prosecuted.
Yes.
See, one fact, one thing I will want to lay down in this, despite doing it. Now, these parents who get their children married before 18, they should be prosecuted. Because children get marriage, they will get married, no problem. But those parents will have to be prosecuted, sensitized so that they should not indulge in such things.
Yes, one such case today is as a child marriage, my lord, where
Ah.
parents have got.
17 years, 8 months or whatever it is. ಕೆಲವು if marriage has resulted in offenses under POCSO,
Yes.
that cannot. ಕೆಲವರು elope ಆಗಿ POCSO ಎಲ್ಲ ಆಗಿರುತ್ತೆ, that we will not do it. If it is 16 years, 17 years, 8 months, fine. But these parents and child marriage restraint act, ಧಾರವಾಡದಲ್ಲಿ ಒಂದು ಬರ್ದಿದ್ದೀನಿ, the parents should be prosecuted.
Yes.
I have quashed the proceedings, but parents should be prosecuted.
Also, I think.
It's only then that will stop.
Correct. Here also one such case, my lord, where parents have got the marriage done. It is not the elopement.
Huh,
It is
that
an arranged
will see.
marriage where it is.
Because boy and girl, if they get married, they will be,
Correct.
they will not say no.
Correct.
We'll see, ಇದು ಎಷ್ಟು ವರ್ಷ?
17 years, 6 months.
Yes, Jagdish.
17 years, 8 months.
17 as on the date of the incident.
Yes, yes.
You are in love with her
Yes.
or parents getting married.
No.
It's only folks.
Now they are married.
Child marriage ಇಲ್ಲ.
Yes, illa.
Now they are married. After
They're
18 years.
Married and
Married, they are living together right now in Bangalore.
custody ಇದ್ದಾರಾ?
ಇಲ್ಲ.
Custody ಏನಿಲ್ಲ
ಇಲ್ಲ.
ತಾನೆ? ಹಾಗಾದ್ರೆ then we will pass some order. Settlement ಎಲ್ಲಿದೆ?
I have filed on joint memo.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದು. Official file.
Anyway, this case we will dispose.
Yes.
17 years, 8 months.
May quote that one coordinated bench judgment, my lord, and the Supreme Court also. None of the matter is.
ಅಲ್ಲ ನೀವು ಕೊಟ್ಟಿರೋ ಇದ್ರಲ್ಲಿದೆ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ one more.
ಇನ್ನೊಂದು ಈ 17 years 6 months ಆದ್ಮೇಲೆ ಇರೋದು ಯಾವ್ದಿದೆ?
ಒಂದು
ಇನ್ನೊಂದು 17 years 11 months ಇದೆ.
ಹೌದು.
That also we will do it. ಅದರಲ್ಲೂ POCSO ಮಾತ್ರ, child marriage ಏನಿಲ್ಲ.
ಇಲ್ಲ.
Wherever this child marriage restraint act is imposed,
Yes, ma'am.
ಅದನ್ನ we will take it. They are not in custody, right?
No.
Then you'll get the copy on 21st. We'll say disposed, but 21st we'll get the copy. ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಮಾಡಬೇಡಿ. ಕಸ್ಟಡಿಲಿ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾವುದು POCSO ಸೆಟಲ್ಮೆಂಟ್?
Child Marriage Act and folks on 47.
ಎಲ್ಲ POCSOನಾ?
No, 47, I had 66, child marriage act.
ಅಯ್ಯೋ, half of the advocates are that only for waiting for those. Yes.
66,
Serial numbers ಹೇಳಿ ಒಂದೊಂದಾಗಿ.
47.
One minute. ನಿಮ್ದು 16 years, don't say. Yes.
CMO 47,
First of the serial numbers ಯಾವುದು?
Next is 66, my lord, is.
ಅಲ್ಲ, next ಅಲ್ಲ, previous pass over ಆಗಿರೋದು.
47.
47. Age of the victim?
16 years, 10 months. And here.
ಈಗ ಏನಾಗಿದೆ?
Charge stage ಇದೆ. My lords,
ಏನ್ madam?
these two.
16, dispose ಅಂತ ತಗೊಳ್ಳಿ. Yes, dispose of.
Lords are pleased to defer the framing of charge. Till this issue,
He's not in custody anyway.
he's not in custody.
Fine. Then,
Here, the complainant herself is the victim. Once she was 18 years. It's a delay of 14 months from the date of marriage in setting the law into motion.
no, who got you married?
Parents,
Like idರಲ್ಲಿ
47, na?
please,
child marriage.
Then we may have to pass a detailed order in this.
Yes.
We'll do it.
Please.
Anyway, I've deferred framing of charges. List on 22nd at 3:30 PM. The order dated 6/8/2024 shall continue till the next date of hearing, because I want to haul up the parents. Yes.
52, my lord.
60?
52, my lord.
52 na 62 na?
52, my lord.
ಏನದು?
ಈಗ 17 years.
ನಿಮ್ದೇನಾ 52?
ಅಲ್ಲಲ್ಲ, ಪೇರೆಂಟ್ಸ್ ಕೂಡ ಆಮೇಲೆ ಅಪ್ರೂವ್ ಹಾಕ್ತಿದ್ದಾರೆ. ಯಾಕಂದ್ರೆ
ಯಾರಾದ್ರೂ affidavit ಹಾಕಿ
ಅಲ್ಲ,
ತೊಂದ್ರೆ.
reason is my lord.
No,
Question is,
You will get acquitted. We'll direct the court to conclude the trial in 3 months.
yes,
I will direct the court to conclude the trial in 3 months.
what are we to?
ನೀವು ಏನ್ ಬೇಕಾದ್ರೆ ಹಾಕಿ. In this case, I will direct the court to conclude the trial in 3 months.
In submission, my submission is, the parents are also here, my lord. In the interest of my lord, the victim girl, my lord, they are getting.
No, sir, I will not. ನೀವು ಏನೇ persuade ಮಾಡಿದ್ರು 15 years and 7 months at the date of the incident.
16, ಈಗ 2 months.
ಇವಾಗ 18 ಇರ್ಬೋದು.
ಅಲ್ಲಲ್ಲ. 2 months.
Is the date of the incident?
Date of the incident, my lord, prior to 2022, she was less than 16 years.
No, sir.
She came to.
Alas,
1 month, 5.5 months pregnant.
16 years,
Sir.
1 month.
16 years, 1 month, when she was 5.5 months pregnant. 15 years, 8 months.
No, complaint ಕೊಟ್ಟಾಗಲ್ಲ, ಅದು ಅವ್ರು complaint ಕೊಟ್ಟಾಗ ಅವ್ರು 16 year.
No, this I'm not going to settle, sir. I will direct the court to conclude the proceedings in 3 months.
ಅವ್ರ ಹಿಂದೆ
Baby is
ಮಗು ಇದೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮಗು I told state will,
Petitioner, my lord,
No, no.
in the custody, my lord.
I will direct the court to conclude the proceedings. Yes. ಇದ್ರಲ್ಲಿಲ್ಲ.
They were about ಮದ್ವೆ ಆಗೋದಕ್ಕೆ ರೆಡಿ ಇದೆ because they are close relative. They were
Parents,
very
my lord,
close relative.
ಅಲ್ಲ, parents ಕೂಡ my lord, ಅವ್ರ ಹಿಂದೆ.
No, sir.
ಯಾರ್ my lord, ಅವರು ಕೂಡ ಅಪ್ಲೋಡ್ ಹಾಕಿ ರೆಡಿ ಇದ್ದಾರೆ, because they will see that my lord, after attaining age of majority, my lord, ಇನ್ನು 2 ತಿಂಗಳಾಗಿದೆ ಅಷ್ಟೇ, ಆಮೇಲೆ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಂಡು.
Very good.
So
Yes.
that's why my lord.
No problem, sir. ಇವತ್ತೇನ್ ಡೇಟು? 16th. Sorry. 9th. List the matter on 25th October. The pendency of this petition will not come in the way of the further proceedings before the concerned court. All right. Yes.
Proceedings, my lord.
Actually, ಮುಗಿದೋಗಿರುತ್ತೆ ಟ್ರಯಲ್ ಬಿಡಿ.
Already victim is residing with victim already ಮನೆಯಲ್ಲೇ ಇದ್ದಾರೆ.
Correct, sir. See, the 15 years, 7 months or 8 months ಆಗಿರೋ act is unpardonable.
Parent ಇಲ್ಲ sir because.
No, sir, I will not do that.
ಏನಾಗಿದೆ ಅಂದ್ರೆ,
I will not settle. I will direct the concerned court shall endeavor to conclude. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಟ್ರಯಲ್?
ಈಗ ಎವಿಡೆನ್ಸ್ ಸ್ಟಾರ್ಟ್ 22nd.
We will direct to conclude in 2 months.
Yes.
That's the best way to dispose this. The concerned court is another better, madam. The petitioner is before this court seeking the following prayer. During the pendency of the petition, it transpires that the petitioner and the family of the petitioner and the accused and the complainant have settled the dispute amongst themselves and have filed a application seeking to compound the offense. Compound the offense. Any observation on the application seeking compounding the offense on the compounding of the offense would prejudice the case of the petitioner before the concerned court. Therefore, the concerned court shall endeavor to conclude the proceedings within an outer limit of 3 months, if not earlier. Outer limit of 3 months, if not earlier. ಸಾಕು ಅಷ್ಟೇ. ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಬಿಡಿ. ಅದಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೇ ಬರುತ್ತೆ ಆಮೇಲೆ.
ಅವ್ರ ವಿಕ್ಟಿಮ್ ಪೇರೆಂಟ್ಸ್ ಎಲ್ಲ ರೆಡಿ ಇದೆ, because ಮಗು ಇದೆ. That's the.
I have told, yes, the endeavor to conclude ಬೇಡ. At any rate, within before 3 months ಅಂತ ಮಾಡ್ಬಿಡಿ. Endeavor ಬೇಡ.
ಕೂಡ
It is needless to observe that the state and the petitioners shall cooperate for conclusion of the trial. State shall not unnecessarily drag the matter by seeking adjournments. ಅಷ್ಟೇ. 1 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಯುತ್ತೆ, ಅಕ್ಯೂಟ್ ಆಗ್ತಿರುತ್ತೆ.
ಅಗೇನ್ the victim will ಏನೋ ಒಂದು ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಸಮಾಧಾನ ಮಾಡಿ.
No, ಸಮಾಧಾನ ಯಾವ ಸಮಾಧಾನ?
ಅವ್ರ ಪೇರೆಂಟ್ ಯಾರು ಇಲ್ಲ ಸರ್, ವಿಕ್ಟಿಮ್ಗೆ ಪೇರೆಂಟ್.
ಪೇರೆಂಟ್ಸ್ ರೆಡಿ.
No, sir, I will not. Any amount of persuasion, I will not. The girl was 15 years, 7 months at the time of the incident. No. Yes. Yes.
2 months or 18 years.
No, sir. ಇನ್ನು 18 ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಆಗುತ್ತೆ.
The 2 months ಅಲ್ಲಿ ಆಗುತ್ತೆ. Not yet 18. ಆಗ್ಲೇ settle.
17 year ಆಯ್ತು.
ಟ್ರಯಲ್ ಮುಗಿಯುತ್ತೆ ಆಮೇಲೆ.
ಟ್ರಯಲ್ ಮುಗಿಯುತ್ತೆ, ಆಮೇಲೆ ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳಿ ಆರಾಮ. By then trial itself will be over.
It was the time 19 years ಆಗಿದೆ my lord. ಆ ಟೈಮಲ್ಲಿ 19 years ಆಗಿದೆ because ಅಂಡರ್ ದಿಸ್ ಅವರ ಇದರಲ್ಲಿ ಕಮ್ಯುನಿಟಿನಲ್ಲಿ 19 years ಆಗಿದೆ. ಓನ್ಲಿ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ SSLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನಲ್ಲಿ ಮಾತ್ರ ಆ ರೀತಿ
ಪರವಾಗಿಲ್ಲ.
ಅದನ್ನು ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
Nothing I'm going to listen. 15 years, 7 months you have indulge in that act, I will not. Yes.
ಅಲ್ಲ ಆಸ್ ಆನ್ ದ ಡೇ 16 ಇಯರ್ಸ್ ಆಗಿರೋದು ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಲೇಟ್ ಆಗಿ ಕೊಟ್ಟಿರೋದು
ಪರವಾಗಿಲ್ಲ sir.
ಆಸ್ ಆನ್ ದ ಡೇಟ್
No, sir, I will not.
ಬಟ್ ಇನ್ಸಿಡೆಂಟ್ ಹಾಕೊಂಡು ಆಫ್ಟರ್ 15 ಇಯರ್ಸ್ 16
He is
ಇಯರ್ಸ್
not even 18 now.
ಅಲ್ಲ ಈಗ ನಾವು 2 ಮಂತ್ ಆದ್ರೆ ಆகும்
No, sir.
Together with that baby is there, we need to take care of baby.
Yes. Next.
66, my lord.
8 or past or 8?
Serial number 8.
60, my lord, serial number 60.
ಅದೇನು?
Foxo, my lord.
66.
Child marriage act ಕೂಡ ಇದೆ ಅದರಲ್ಲಿ.
ಇದೇನು?
17 years.
66, 17 years.
17 years.
Now, marriage also registered, my lord.
8.
Why did this parents get custody ಇದ್ದೀರಾ? ಇಲ್ಲ ಅಲ್ವಾ?
Page number
22nd.
92 is marriage certificate.
22nd.
67. 8 ಅಲ್ಲಿ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಗ್ತಿದೆ.
8 months. Okay, don't, let's go by say, ಒಂದ್ ನಿಮಿಷ. First, ಒಂದ್ ನಿಮಿಷ ಎಲ್ಲೆಲ್ಲೋ ಹೇಳ್ಬೇಡಿ. ನಾವು ಫಸ್ಟ್ 52 ಆಯ್ತು, ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು? Passed over 8 ಯಾರ್ದು?
ಪ್ಲೀಸ್ for petition.
That also is 16 years.
Yes.
That is again, trial will get concluded, that's all.
Lord,
No, sir. No, I'm not getting persuaded.
at the time of the incident she was 16 years 6 months. And also
But list on,
That
you are in
is a-
custody?
no, my lord,
List on
even the
22nd.
parents and the family
List on
members of-
22nd. Yes, these parents I am going to write. That is why 22nd.
my lord, these 164 statements she
Again,
can take states that-
Custody ಇಲ್ಲ ತಾನೆ?
no, my lord.
22nd. Yes.
Please,
Serial number 68, my lord. Sir, present 17 year 8.
ಯಾವ್ದಾಯ್ತು? ಒಂದ್ ನಿಮಿಷ. ಈಗ ಯಾವ್ದಾಗಿದ್ದು? Serial number? Serial number 8 ಆಯ್ತಾ? 8 madam, 22nd. Yes. Next ಈಗ. Sir, ಧಾರವಾಡ wait. Yes. ಒಂದ್ ಮುಗಿಲ್ಮೆ ಒಂದ್ ತಾನೆ? Wait sir. Yes.
66.
66.
Hmm.
66. Child marriage act and
22nd. Yes.
serial number 68, my lord.
17 year 8 month Pox Act.
Yes, Jagdish.
No, child marriage, parents of daughter
Then 20,
marriage.
you are not in custody?
Not in.
22nd.
I may be permitted to furnish the joint petition.
ಅದು ಫೈಲ್ ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ.
CM 67, your honor.
Poxo case.
Also, Foxo.
67.
Also,
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
also.
ಏಜ್ ಏನು?
17 years, 9 months, 27 days, your honor.
At date of the incident?
17 years, 43 days.
Child marriage?
Yes, yes.
17
Child
days.
marriage?
Child marriage.
Child marriage, your honor. Child marriage.
ಇಲ್ಲಪ್ಪ, ಒಂದ್ ನಿಮಿಷ. Talking to some. Child marriage restraint act?
Yes.
20 is in custody?
ಇಲ್ಲ sir.
22nd. 57 also 67, 22nd.
69.
Yes, Hemant.
They are having 1 year 4 month child. 16.5 years at the time of the incident. The doctor has given the complaint.
ಇದು child marriage restraint act.
ಅಲ್ಲ ಇಲ್ಲ ವಾಲಂಟರಿಲಿ ಗಾಟ್ ಮ್ಯಾರಿಡ್ ಬಟ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರಿಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕ್ಲೇಬೇಕು.
ಹುಡುಗ ಹುಡುಗಿ ಅವರೇ ಮದುವೆ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಕಸ್ಟಡಿ ಇದ್ದೀರಾ?
ಕಸ್ಟಡಿ ಇಲ್ಲ
ಕಸ್ಟಡಿ ಇಲ್ಲ ತಾನೆ?
ಹುಡುಗಿ 18 ವರ್ಷ ಈಗ.
ಕಸ್ಟಡಿ
ಇಲ್ಲ.
22nd.
1 month. 16 year 1 month.
22nd we'll see. ಅವತ್ತು ಕ್ಲೋಸ್ ಮಾಡಿ.
Number 70. 70. 70.
ಓನ್ಲಿ ಪೋಸ್ಟ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಇಲ್ಲ.
Only?
Post.
Poxo.
Child marriage illa. As on the date of incident, 17 years 9 months.
Yes, Jagdish.
18 years 10 months.
ಇದ್ರಲ್ಲಿ child marriage ಇಲ್ವಾ?
ಇಲ್ಲ.
17 years 9 months.
As on the date of complaint.
ಇವತ್ತು what is the position?
18 years 10 months. They are married, registered married.
ಎಲ್ಲಿದೆ ಸರ್ಟಿಫಿಕೇಟ್?
On the page number 106.
You have a child?
No, ma'am. In the page number 106, I have produced the marriage certificate and along with the invitation card. 106 and 107.
If you leave her, then Poxo will be back.
Yes, ma'am.
106? Sir.
106 and 107.
Certificate ಅಲ್ಲಿ?
107.
5/6/24. When did you get married?
On 5/6/2024.
Yes, Jagdish.
Bottom of the page.
17 years 4 months.
On the date of the incident. Yes. ಇದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಅದು 21st ಆದ್ಮೇಲೆ ಕಾಪಿ. Yes. ಮೇಡಮ್ ಅದೆರಡುನು ಏನದು ಬಂದಿಲ್ಲ ಕರ್ದ್ಬಿಡಿ ಒಂದ್ಸರಿ.
Past or not? 18?
ಹಾ
Idರಲ್ಲಿ, the application, my lord, is the document which my learned friend submitted is wrong. He is only showing that one, he made an attempt to make a registration, he is not done. His application finally, my lord, is filed only on 21/12/2021.
ಹಾ
After the expiry of the license.
ಆಯ್ತು, ಪರವಾಗಿಲ್ಲ. ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ ಅದ್ರ ಮೇಲೆ?
That is subsequently it was allowed only in 2024.
What did you say? Well, July 24 it is allowed.
ಹೌದು.
So it is deemed.
ಅಲ್ಲ, ಕಂಟಿನ್ಯೂಷನ್ ಇರ್ಲಿಲ್ಲ.
ನೀವ್ಯಾಕ್ ಮಾಡಿದ್ರಿ? ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾಯ್ತು.
ನ್ಯೂ ಅಪ್ಲಿಕೇಶನ್.
ನೀವು ಅಲ್ಲ.
New ಅಲ್ಲ ಸ್ವಾಮಿ.
ನಿಮಿಷ.
My lord, I'll make my submission.
Has been granted.
Place, my lord, the application which.
ಇದು ರಿನ್ಯೂವಲ್ ಹಾಕಿದ್ದ ನೀವು?
ಅವರು ಫಸ್ಟ್ ರಿನ್ಯೂವಲ್ ಹಾಕ್ತಾರೆ,
ಹಾ
ಅದನ್ನ ಪ್ರೋಸೆಸ್ ಮಾಡಲ್ಲ.
ಆಯ್ತು,
ಅದನ್ನ
ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, they didn't pay the
ಅಲ್ಲ, ಅವ್ರು ರಿನ್ಯೂವಲ್ ಹಾಕದ್ ನೀವು ಅವ್ರು ಪ್ರೋಸೆಸ್ ಮಾಡಲ್ಲ, ನೀವೇನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಅವರು ರಿನ್ಯೂವಲ್ ಆಗ್ತಾರೆ ಅಂದ್ರೆ they have to pay the DD.
They have not paid?
They don't pay. No. So therefore the application was actually not processed, not even submitted to us. Finally in 2021 he submits this application. This is considered as a new application.
12/2021.
Yes. If it is.
ಆಯ್ತು, ನೀವು ಈಗ ಸರ್ಚ್ ಮಾಡಿದ್ಯಾ ಅವತ್ತು?
This is before granting of this. It was on.
Before granting this registration.
Yes, ma'am.
ಆಯ್ತಾ?
February 20.
No problem. 2/12/21 ಹಾಕಿದ್ದ ಅಪ್ಲಿಕೇಶನ್ 4th July ವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
He has not submitted various documents.
What document? Where have you notified him that document?
They have notified.
When?
The application only, they have notified.
When?
The application was returned on 4/6/2022.
1 ವರ್ಷ ಆದ್ಮೇಲೆ?
ಅಲ್ಲ, 21/12 ಗೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
2/12/2021 is the application.
Yes, my lord.
4/6/2022 you have returned it.
Yes, my lord.
6 months, why did you take to return it?
That is what they have.
Sir,
That itself is deemed.
no. Sitting in a glass house, you're trying to throw stones at those people. What do you do? Tell me. 6 ತಿಂಗಳು ಒಂದು ಅಪ್ಲಿಕೇಶನ್?
ಅಲ್ಲ, ಅವರು
ಅಂದ್ರು
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
Sir, you should put, the state should put its house in order. 6 months for an application seeking renewal or otherwise you sit over it and go on search and seizure in everything. That is why I say you should put your house in order first.
That's correct.
First, you should dispose the applications that come. ಏನ್ ಇದ್ರಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬರೆಯಕ್ಕೆ ಬೇರೆ ಕೆಲಸ ತುಂಬಾ ಇರುತ್ತೆ. A lot of other work which are more interesting. 6 months you take to, and under section 7
Yes.
of the act, if you don't, new application ಅಂತಾನೆ ತಗೊಳ್ಳೋಣ, ತೊಂದ್ರೆ ಇಲ್ಲ. It is deemed.
No, the deemed comes only for the renewal, not for the.
What else is this?
No.
ಅಲ್ಲ, ಡೀಮ್ ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ, not renewal.
ಇದೆ. PCP and
Section 7 ಅಲ್ಲಿ any application for renewal or whatever it is.
Well, that difference is there in the PCP NDT Act, not in the KPME Act. Even for the fresh application, it will be applicable for the, under the KPME Act, my lord.
It's not correct. ಸುಮ್ನೆ act ಇದೆ ಅಂತ ಸೀಸ್ ಮಾಡೋದು.
ಅಲ್ಲ, factually ಏನಾಯ್ತು
No,
ಅಂದ್ರೆ
you see in that matter which I have pronounced now, no allegation.
Yes.
That's why I told you, this act is meant to stop female feticide.
Correct.
ಅದು ಯಾವಾಗ ಗೊತ್ತಾಗುತ್ತೆ gender?
Post-
After 14 weeks. All the scanning that has done, that is undertaken in that scanning machine is 6 weeks, 5, 6, 7 weeks. You will not even know. Then how do you seize it? Seize it saying they are taking sex detection. You won't even know.
Rule 12 ಅಲ್ಲಿ there are other guidelines that mandated for them to follow. which they have not followed.
ಆಯ್ತು, Rule 12 guidelines ಇದೆ. You come to Rule 12.
Yes.
It also says that your officer should visit every place of this kind
3 months.
every 90 days.
Correct.
Do you do that? ಯಾವ್ದೋ ಒಂದು ಇನ್ಸ್ಟೆನ್ಸ್ ಆದ ತಕ್ಷಣ everywhere you go on doing it. In the rush of implementation of the act, you do it.
That's correct. That is what has happened. in this.
ಮತ್ತೆ ಎಲ್ಲ you should have some procedure in place. Procedure is in place.
There-
It's a paper tiger. Nothing else you are doing in it.
That's correct.
ಮತ್ತೆ everything ಎಲ್ಲ act ಆದಾಗ no, it's PCPNDT act, court should not interfere. This is the way of doing it. No, sir. You should set your house in order. Otherwise, these things will go on like this. Officers should know that they cannot sit over the applications for, all time. 6 ತಿಂಗಳು, 1 ವರ್ಷ, 4 ವರ್ಷ. See this.
Yes, ma'am.
2/12/2020, it is returned, all right.
Yes.
He has again submitted it,
He is resubmitted on 14/6/2022.
14/6.
2022.
When do you grant it? 4/6/2024. 2 years you have taken after resubmission.
Yes.
Where? Smacks of complete callousness. This is not correct.
My lord, that the second
ನಿಮ್
application.
ಸ್ಕ್ಯಾನಿಂಗ್ ಮಿಷಿನ್ ಬಿಟ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಂದು ಫ್ಯಾಕ್ಚುಯಲ್ ಸಬ್ಮಿಷನ್ ಏನಂತಂದ್ರೆ
ಹ್ಮ್.
ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಈವನ್ ಪ್ರಯರ್ ಟು ದ ಎಕ್ಸ್ಪೈರಿ ಆಫ್ ಮೈ KPMA ಲೈಸೆನ್ಸ್ ಇನ್ ದ ಇಯರ್ 2019. ಅದಾದ್ಮೇಲೆ
That
ಏನಾಗುತ್ತೆ?
you don't pursue it.
ಇಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಏನಾಗುತ್ತೆ ಅದರಲ್ಲಿ ಅಂತಂದ್ರೆ ಅವರು ಒಂದು ಆಫೀಸಿಂದ ಇನ್ನೊಂದು ಆಫೀಸ್ಗೆ ಶಿಫ್ಟ್ ಮಾಡ್ತಾರೆ. ಶಿಫ್ಟ್ ಮಾಡಿದಾಗ ನನಗೆ ಹೇಳ್ತಾರೆ ಅವರು, ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಕಳೆದೋಗಿದೆ, ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ದೇರ್ ಫಾರ್ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ರಿಕ್ವೆಸ್ಟ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಒನ್ ಮೋರ್ ಅಪ್ಲಿಕೇಶನ್.
Now, who is in charge of this?
No,
Who grants these applications,
Yes.
permission on these applications?
this is done by Karnataka Private Medical Education.
Who is the officer? Will impose some costs on him
Is a district
to be
appropriate.
recovered from his salary.
Is a deputy commissioner, my lord.
District Health Officer.
Huh?
District Health Officer.
No, my lord, as per the
PHO.
KPMA Act, my lord.
One ನಿಮಿಷ,
the-
ನಿಮಿಷ.
The district registration and the grievance redressal authority is the competent authority. to
Grievance
issue the license.
redressal, sir. 1 minute. Who has to grant permission on these applications? Grievance redressal is
ಇಲ್ಲ
different.
Swami.
My lord, kindly seek section 17 of the KPMA Act.
So it is deputy commissioner, huh?
Yes, my lord.
Okay.
He is the chairman of that committee.
Committee grants permission or officer?
No, my lord, as per the act, my lord, as per, in view of the section 17 of the KPMA Act, my lord, there is a committee constituted in order to issue a KPMA license, my lord.
License, yes. So that committee ಮುಂದೆ ಯಾವಾಗ ಇಟ್ರಿ ಏನು? I will direct henceforth, if the committee does not consider the applications within 2 months under the act, it will be deemed ಒಂದು and they will have to pay costs.
Really, my learned friend says, my lord, in 2019, he moved an application.
Forget it, sir. I'm not taking 2019 at all.
Yes.
Whatever it is, he may tell a story or whatever.
Correct.
But 2021 is on record, 14/6/22 is on record, and you have taken 2 years to grant that license is on record. What else?
We should have rejected then, and they're saying that this
Exactly.
is not.
What other illustration of callousness you need?
That's correct. We should have rejected then.
Yes.
Some things are not there, we should have rejected them.
Yes,
Yes.
that's, no, there should be some
That's
method. Accountability, no responsibility. This is not correct. Yes, we'll
No, he is asking-
release the scanning machine now.
Yes,
I'll pass a detailed order later.
My lord, also, on the
Be
date
very
and,
nice.
my lord, my submission is that.
What else you want, sir? Patients ಬೇಕಾ?
ಎಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
ಸ್ಟೇ ಇಲ್ಲ ಅದರಲ್ಲಿ, ಚಾರ್ಜಿಗೆ ಬರ್ತಾ ಇದೆ.
ಅದನ್ನ ನಾನು ಮಾಡ್ತೀನಿ. Yes. Heard the learned counsel appearing for the petitioner and the learned additional SPP for the respondents. The matter is heard at length. Awaiting, heard at length. There shall be an interim order directing the release of the seized scanning machine of the petitioner. Next, the concerned court, the proceedings before the concerned court in CC 10586 of 2024 shall remain stayed till the next date of hearing. List the matter on 23rd at 4 PM for dictating orders. 23 ಬೆಳಗ್ಗೆ ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. It's a matter to be stayed. Nobody is representing. Sandesh Chowta? Last time. Avinash Gowda.
Yes.
Huh?
Case and ನಾಲ್ಕು
Correct. Clearly politically motivated complaint.
ಎರಡು ಕಡೆ.
In Congress BJP problem. ಅವರು complaint, ಇವರು
So this is a matter where 4 FIRs.
ಬೆಳಗ್ಗೆಯಿಂದ I know.
I'm sorry.
Serial number 23.
23 ಅಲ್ಲಿ 2
Where
complaints
is your
given by.
instructing counsel? Madam. Kirtana, stand with
No,
him.
sorry.
He is here, yes.
My lords, crime number 81 to crime number 84. Election day, my lords.
No, this is a matter to be straight. I passed it over because nobody represented in the morning.
Sorry, my lords, I don't know.
Who is Avinash Gowda?
My lords,
ನಿಮಗೂ ಗೊತ್ತಿಲ್ವಾ? Yes, one additional SPP, 2 emergent notice. In the meantime, I heard the learned senior counsel ಅಂತ ಮಾಡಿ, in the meantime, so and so, and there shall be an interim order of stay. List the matter on 11th September in the fresh matters list.
apology, my lords, I'm
Yes,
sorry.
yes. ಬೆಳಗ್ಗೆ I said it's a matter to be stayed, nobody is coming. Then I saw you have appeared earlier.
I'm sorry.
30.
30 my lord, 20th that one I'll reply.
20th. ಅಲ್ಲಿ ಏನಿದೆ ಸ್ಟೇ ಇದೆಯಾ?
I'm
ಇಂಟರ್ ಮಾಡೋ ಕೊಟ್ಟಿದ್ದೀನಾ?
not aware about the matter, my lord. My senior is engaged in this matter. I'm just,
ಮಧುಕರ್,
please, my lord. My
list
senior.
on 20th at the request of 20th ಬೇಡ 21st ಇರ್ಲಿ. List on 21st at the request of the learned additional SPP who seeks time to make his to submit a reply to the submissions made by the learned counsel to the petitioner.
33. Oblige me. Or as.
Settled,
Settled.
ಇರ್ಲಿಲ್ಲ ನೀವು.
Both parties are also present before
All
the
right.
court.
ಅಷ್ಟೇ.
Only thing is now.
421 ಅಲ್ಲಿ ರಿಕವರ್ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ರೆ 6 months ಆದ್ರೂ ಸಿಗ್ತಾ ಇರಲಿಲ್ಲ.
ಇಲ್ಲ,
You will be
ಇದರಲ್ಲಿ ಆ
roaming
ತರ
around
ಇರ್ಲಿಲ್ಲ.
everywhere.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಆ ತರ ಇರ್ಲಿಲ್ಲ. There was a memorandum.
This is why I say, once you settle in Lok Adalat or compromise before a court and you don't adhere to it, crime will get restored. I have written, because the accused will roam free. Yes. ಯಾಕಂದ್ರೆ 421 ಅಲ್ಲಿ ಹಾಕಿ ಅದನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಸಿ, ಇಟ್ಸ್ ಅ ಲೆಬೋರಿಯಸ್ ಪ್ರೋಸೆಸ್ ವೇರ್ 5 years ಅಲ್ಲೂ ಸಿಗಲ್ಲ ದುಡ್ಡು.
Should be there. That should
ಮತ್ತೆ
be there.
ನೀವೇ ಈ
Otherwise
ಕಡೆ
nowadays-
ಬಂದು ನೋಡಿ.
Correct.
You be on the side of the complainant.
I have seen it. I have
Then
seen it. I have
That
seen
is
it.
why these 421 ನಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ರು. Well, crime gets restored immediately if you don't adhere to the settlement.
Now it is settled, my lord. Only thing is, 21 lakh I have deposited before this honorable court.
That will be
Out
given.
of that, 20 lakhs has to be given to the respondent. 1 lakh to be refunded to the.
Settle ಆಗಿದೆಯಾ ಅದೇ ತರ?
ಆಗಿದೆ.
Humble submission. Your Honor.
Yes, madam.
Any deposits in the trial court should be there.
Trial court ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಇದೆಯಾ?
Trial court only because I have not appeared and they are also not sure.
ಇದ್ರೆ
ಏನೋ
ತಗೊಳ್ಳಿ.
surety deposit
ಅವ್ರು
ಏನಾದ್ರು
ಕೇಳಿ
ಇದ್ರೆ
ಇದೆಯಾ
ಇರ್ಬೇಕು.
Is there?
ಇದೆಯಂತ?
ಅದನ್ನ ಅವರಿಗೆ ಕೊಟ್ಬಿಡೋದು.
ಆಯ್ತು, obviously. Yes, the petitioner is before this court calling in question a fine levy warrant FLW issued against the petitioner in CC 3781 of 2020 so and so. The fine levy warrant comes to be issued on the score that the petitioner has not adhered to the settlement in a proceeding arising out of an offence punishable under section 138 of the Negotiable Instruments Act. The petition was preferred on the score that the fine levy warrant cannot result in a proceeding in section 421 of the CRPC cannot result in a fine levy warrant. This court had passed the following order on 12/7/2024. The parties have now settled the dispute amongst themselves and have filed a
Joint memo.
joint memorandum of settlement. The learned counsel for the parties would submit all the terms in the memorandum of settlement are complied with. The deposit made, ಎಲ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲಿ ಮಾಡಿದ್ರು.
The deposit made before this court in terms of the order dated 12/7/2024, read with 19/7/2024, shall 924 shall be released in favor of the respondent. The learned counsel for the respondent submits that there is certain deposit made before the trial court as well. Even the deposit made before the trial court also shall be released in favor of the complainant, in favor of the complainant on complainant within 2 weeks from the date of receipt of a copy of this order. In 1 lakh ಯಾರಿಗೆ?
ಅಲ್ಲಿ 1 lakh petitioner ಗೆ 21 ಲಕ್ಷ ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ. 20 lakhs will go to the respondent. 1 lakh has to be refunded to the petitioner. That is the
All right, so and so.
in the memo I have
The
mentioned.
settlement appears to be that the petitioner, the complainant would get 20 lakhs out of the 21 lakhs in deposit before this court, and 1 lakh would go to the accused.
Yes.
Accused. In the light of the settlement, in terms of settlement ಎಲ್ಲಿದೆ?
Memo I have filed just now.
ಇದಾ?
Prayer notice.
The settlement reads as follows, East Matra. In the light of the settlement, the proceedings stand closed.
Fast ಆಗಬೇಕಾಗುತ್ತೆ.
The
ಇದರ ಮತ್ತೆ
fine levy warrant issued in the proceeding initiated under section 421 also stands quashed. Also stands quashed. Yes.
Order sheet signatures. The order sheet, sir.
signature.
Yes. ಅದೇನ್ ಮೇಡಮ್? ಏನದು? Oh, correct. 22nd ಹಾಕಿ. List on 22nd.
Both the senior counsels are just outside. I have told my colleagues.
Outstanding senior counsel?
They're just coming.
Yes. Pass over.
That's
ಏನ್ ಮೇಡಮ್ ಅದು? Why 46? Settlement?
Yes, your lordship. Hearing for the response.
Boxo?
Two.
No. 498A,
Where is the settlement?
joint petition is filed.
Page?
No, it is filed. Already the respondent number 2 has filed no objection. It was the FIR.
Respondent number 2 is the complainant?
Yes, your
Yes,
lordship.
complainant.
ಕುಲಾನಾಮ ಇಲ್ಲಿ ಅಂತ ಕೇಳಿದ್.
Along with no objection set
No objection.
that has been filed by the
Memo, Your
respondent
Worship.
number 2.
Where is that? Which page? ಇಲ್ಲಿ. Yes. Madam,
number
498A. ಇಲ್ಲಿ ಫ್ಲಾಗ್ ಅಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಅಂತಿದೆ. ದಟ್ಸ್ ಕಾಲ್ಡ್ ಕುಲಾನಾಮ. ಅದನ್ನ ಇಷ್ಟು 2-4 ಲೈನ್ ಇದೆ, ಅದು ಕೊಟ್ಟು ಮಾಡ್ಬಿಡು. ಇದೆಲ್ಲ ಎಸ್ ಕ್ಲೋಸ್ಡ್.
Much obliged.
Order sheet signatures.
ಇದು ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ. ಇದಿತ್ತಲ್ಲ ದಟ್ ನಾಗೇಂದ್ರ ನಾಯಕ್ ಅವ್ರು ಮಾಡಿ.
72.
ಸರ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಏನೋ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಅಂತ.
ನೋ ಐ ಹ್ಯಾವ್ ಟು ಫಿನಿಶ್ ದಿಸ್.
ಐ ವಿಲ್ ಕಂಟಿನ್ಯೂ.
ಅಲ್ಲ, ನೀವು ಅವ್ರು ಶುರು ಮಾಡಿದ್ದಾರೆ ಟು ಫಿನಿಶ್ ದಿಸ್. ಇಲ್ಲೇ ಇದ್ರೆ ಎಲ್ಲರೂ ಬರಕ್ಕೆ.
ಇಲ್ಲ, ಬಂದಿಲ್ಲ ಅಂತ.
ಬೆಳಗ್ಗೆ ಇದ್ರು. He was here for another case. ನೋಡಿ, if he is there, get him.
Engineer requested CBI also, some personal inconvenience is there.
CBI ga?
ಅವ್ರಿಗೂ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ personal inconvenience. As well as the
Then list 72 na, list this matter on Tuesday. ನಿಮಗೇನು inconvenience ಇದೆ?
ಮಂಡೇ ಟ್ರಯಲ್ ಇದೆ.
List the matter on Tuesday. ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
Wednesday my lord.
ಇಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಇಲ್ಲಿ.
Tuesday, list the matter on Tuesday in the fresh matters list. ಅವತ್ತು ಮುಗಿಸ್ಬಿಡಿ.
Tuesday my lord.
We are not there, my lords, Kalburgi matter.
No, no, no.
Wednesday, my lords.
Whatever you want, arrangement you want to make, you make.
Direction may not be from the court.
No, 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 I will not. This, that is why I will not permit this.
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ, ಐ ಲೈಕ್
ಅಲ್ಲಿ ನೀವು ರೆಡಿ ಇದ್ದಾರೆ, ಮತ್ತೆ ಸರ್ ಬರ್ತಾರೆ.
Wednesday ಗಂಟ.
No, no Wednesday, sir. Tuesday you want to finish it. Prasanna Kumar, ನೀವು ಅಷ್ಟೇ Tuesday ಮುಗಿಸ್ಬೇಕು.
I'm ready, I'll finish it.
ಮತ್ತೆ you don't take time.
I'll not take time.
Because there is a direction to conclude, I will not do that, yes. Tuesday in the fresh matters list, yes.
Yes.
ಮತ್ತೆ ಟೈಮ್ ಇಲ್ಲ. ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಇರೋದು, ವೆದರ್ ಇಟ್ಸ್ ನ್ಯೂ ಟ್ರಯಲ್ ಆರ್ ಇದು ವೈ, ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ. ಸೀನಿಯರ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಹಿಯರಿಂಗ್ ಇಟ್, ಎಸ್.
Senior ones.
ನಿಮಗೂ 1 hour ಬೇಕಾ?
ಇಲ್ಲ, ನಂಗೆ 1 hour ಬೇಡ, ಒಂದು ಅರ್ಧ ಗಂಟೆಯಲ್ಲಿ ಮುಗಿಸ್ತೀನಿ.
ಅದೇನು ಅರ್ಧ ಗಂಟೆ?
ಇಲ್ಲ, ನ್ಯೂ ಟ್ರಯಲ್ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಲೀಗಲ್ ಪಾಯಿಂಟ್ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಇರೋ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನಮಗೂ ಅವ್ರಿಗೂ ಇಬ್ರಿಗೂ ಒಂದರಲ್ಲೇ ಇದೆ ಎಲ್ಲಾನು. ಐ ಮೇ ರೀಡ್ ಸಮ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಯು ಮೇ ರೀಡ್. ಐ ಆಮ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ರಾಚೆ, ವೇರ್ ಇಟ್ ಸೇಸ್ ಫ್ಲಡ್, if the offense is distinct and separate, then question of new trial will come. Here, my lord, there is additional accused are brought in when the trial was at the advanced stage.
That's all right, we'll see. We'll answer the legal issue, no problem.
Please,
Yes. Tuesday in the fresh matters list.
please.
ಇಲ್ಲ, Tuesday I'll give you a specific time. We'll have it at
2:30 ತಗೊಂಡ್ಬಿಟ್ರೆ at least
2:30.
ಕಂಪ್ಲೀಟ್ ಆಗ್ಬಿಟ್ಟು.
2:30 ಅಷ್ಟೇ. Tuesday 2:30. Yes. And ಅವತ್ತು ಟೈಮ್ ಇಲ್ಲ. ನಾನು ಟ್ರಯಲ್ ಡೆಫರ್ ಮಾಡಲ್ಲ, ಇವತ್ತು ಮುಗಿಸ್ಬೇಕಾಗಿತ್ತು. ಎಸ್,
Trial is already deferred, my lords, because the continuous 3 days trial was fixed.
ನೋ
Now it is
ಪ್ರಾಬ್ಲಮ್.
deferred.
Tuesday finally.
Then Wednesday.
No Wednesday, Tuesday. You want to submit on Tuesday.
Let him not take summons on Monday, because what happens is how the trial has to be conducted is also.
No problem. List on Tuesday. Yes. Now get back to that matter.
Apologies, my
All senior counsels are out.
sorry, sir.
We're standing out, I believe.
Sorry, my lords. Apologies.
And I said, yes, of course, they're outstanding
But
counsels.
we were together only, in fact. Yes. My lords, there are 2 matters. One petition filed by the wife, I'm appearing for the wife, for quashing an FIR registered against me for extortion and cheating. And
Against the wife for extortion and
yes,
cheating.
extortion and cheating, and I would like to make out how absolutely none of those offenses are made out, and therefore, and I have filed an FIR under 498A, which has been registered.
Mm.
He has filed a petition to quash that.
Mm.
Interim orders are there in both petitions,
Mm.
and I have sought for vacating of the interim stay in mine. So, my lords, I wanted to actually submit on
Mm.
that. Yes.
Make my submissions, my lords. The marriage in question has
Because
taken place.
There is a vacating stay application, right?
How?
ಹೇಳಿ.
Marriage in question was in 2007, my lords.
Mm.
From 2020, they have not been staying together, my lords. The wife along with the 2 children have been staying at Bangalore. He's at Mangalore. 2023 is a complaint, my lords, alleging 498A and 506, which we have sought for quashing, and there is an order of stay. Now, the sequence of events, my lords, because there are about 8 proceedings against each other, I've done the list of dates. Sign.
Yes.
Could I just take my lords through the sequence? My lords, 2007 marriage, 2 children from the wedlock, my lords. 28/4/2016, this is where the problem begins. If that is noticed, my lords, 28/4/2016, the petitioner, he receives a message from one lady, my lords, who complains that her husband is having an illicit relationship with my wife. This is the message that he gets.
Sorry? Her husband is having illicit relation with your wife.
my wife. That's the message that comes, and that is part of it, my lords. I will just point it out.
Hmm.
So, my lords, I would question my wife about it. And my lords, obviously, my lords, it led to a lot of disharmony between the husband and wife. And then, my lords, post that, this was in 2016, though they were under the same roof, my lords, they were virtually not living together as husband and wife. Then, my lords, 2020, she leaves the house, 10/9/2020, shifts to Bangalore, my lords, and she stays in a flat which I had provided for her in Bangalore, a 4-bedroom flat, my lord. Then, my lords, the legal notice comes, which is Annexure C, the first of the legal notice in 2020, 5/10/2020, where, my lords, she would ask for termination under mutual consent. This is the notice that we received. And thereafter, my lords, after issuance of this, there were a lot of talks within the family members as to how to settle this. There were 2 children also, my lords, taking that into consideration. Now, my lords may notice page 2, my lords. Through another council, the second legal notice we get, my lords. 15/3/2022, through another council, the second legal notice calling for a settlement, failing which threatening to initiate criminal proceedings. This is what the legal notice says. Then, my lords, they would also send a rejoinder after that saying, the parties have started the mediation proceedings to sort out the issues pending between them. Then, mutual meetings, my lords, settlement agreement was drafted by the petitioners council, same was shared via email, all those are there, my lords. And the terms of settlement which was passed on between the parties is, my lords.
No, before we proceed further, it's not settlable now?
No, my lords.
All
In
right.
fact,
Yes.
it's not.
We'll just
And I
continue,
will
my
point
lords.
out.
No, if it's not, then we'll
Please,
hear
my
it. Yes.
My lords, post that, my lords, when the settlement didn't come through, kindly notice, my lords, point 1 to 5 at page 2. What is it that is being paid, my lords? Petitioner continues to pay 2 lakhs towards monthly maintenance of respondent number 2 and the children from the date of separation till date. This is one thing that has been happening, my lords, from 2020. Then, my lords, he's provided a 4-bedroom flat for respondent number 2 and kids to reside. Flat belongs to the petitioner only, my lords. It's not a transfer of flat to them. Then, my lords, school expenses of 24 lakhs is being paid by the husband. Then, my lords, he's provided a credit card to the respondent number 2 for a credit limit of 10 lakhs a month. The said credit card was in use till the date of separation, that is, from the date of separation from 2020, it comes to be blocked in April 2024 after the other proceedings, as I will point out, my lords.
No, the husband has provided all this to the wife.
Yes.
All right.
Please, my lords.
Pa-
Then
pa-
2
pa-
high-end cards.
1 minute. Pause here for a minute. Why extortion case then?
I will
When
point
you have
out.
yourself given everything, where is the question of extortion?
Kindly notice the sequence after that, my lords. After this is all, my lords, in 2020 coming up till 2024. My lords, so far as my case of cheating is concerned, my lords, which has also been stayed. So both the matters are under stay before this honorable court. I would say, my lords, how the money has been taken by her father, my lords. That I'll point out in the complaint. Anyway, the fact remains, I gave a complaint, she's given a complaint, both of which are
No,
stayed.
if it is complaint versus complaint, we will see.
Yes, my lords.
But if you have charged the wife with extortion after giving
Yes,
flat, money,
I
credit
understand
card,
that. I
high-end
understand
cars,
I
how
understand.
can that become
Kind-
extortion?
My lords, kindly notice the sequence after that, my lords, because when it comes to my case, my lords, probably I will be falling back on this Achin Gupta's case.
That's all
On
right.
the sequence, my lords.
See,
Please
you-
notice the sequence.
498A,
And
you tell me, we will answer. But if you are charging the wife of extortion
probably,
of
my lords,
money,
that's why on the previous occasion also, my lords, subject to correction, I had pointed out this would be a case where both the criminal proceedings are liable to be quashed, for which my learned friend did not agree, my lord. She said it
leave it to me.
it has to be quashed in so far as one FIR.
Why would she agree?
So, my lords, please,
Exactly.
Leave it to me, we will do it. What is to
my
me?
lords, please notice the sequence after that. 7/10/2023.
Yes.
My lords, she would file an application under section 10, my lords, seeking judicial separation.
All right.
Then, my lords, post that, say 8/10/2023, this is a complaint, my lords, which is subject matter now. Please notice, my lords, files a complaint stating that 15th June 2020, now her whole case is this, my lords. 2023, the FIR is registered. She says 2020, I had an old phone. I had given my old phone to the children.
Gold phone?
Old phone.
Old
Old phone. My old phone had been given to the children, which she was able to access. In that, she was able to see several WhatsApp messages and various messages which are virtually derogatory. Now that
Against whom?
my lords, my conversation with my friends, where they say that we have spoken about women with the very loose character. That seems to be the.
Fact.
I will just show
1
it.
minute. I'll
My
get
lord,
back.
I will complete the whole thing, my lords. I will
Let him-
point
let him
out.
finish.
Yes,
So
yes.
that seems to be the main essence of this complaint which is given to say it's a case of cruelty. How I have committed cruelty to the wife illa. Ultimately, my cruelty should be either physical or mental cruelty to my wife. That does not seem to be the complaint. The complaint seems to be she happened to get that old phone of mine in which all this was there. And therefore, it is a case of 498A because she is mentally disturbed. This appears to be the case, my lords. Now, kindly notice after this what happens, my lords. After having done this, then respondent number 2, my lords, she would file maintenance under 125 CRPC. So this is the next proceeding initiated, third proceeding, my lords. Thereafter, my lords, she would file under the Domestic Violence Act. That happens on 11/10/2023, the Domestic Violence Act. And there, my lords, what is granted as interim maintenance is a sum of 2 lakhs, which in fact I had been giving. So after this order is when, my lords, I blocked my credit card, which I had given to her, my lords, for an access to up to 10 lakhs. I blocked that, my lords, after an order came from the court.
Blocking order came.
I'm sorry, my lords.
Order to block. Yes.
My lords, anyway, I have been taking care of the education of the children.
Then what?
I have provided a flat to her in Bangalore. And my lords, then a suit is filed, my lords. She files a suit against me saying I should not be making any derogatory statements against her or nothing in the media. She filed a suit. And there's an order in that suit which is also pending.
Well, you had begun to do that, is it?
No, my lords, I really don't know. Once I start, probably, my lords, in cases of this nature, as soon as we go to the lawyer, it'll be 3-4 cases, one after the other, which is filed. Domestic violence, it comes under 498A, then it comes under 125, and probably, my lords, now even 376, my lords, marital rape.
Package. Oh.
Hage agudu. That's why, my lords, the sequence is important. See from 2020 what all happened, and in that backdrop, whether the ingredients are constituted in this complaint. My lords, thereafter there are hardly any more events, my lords. I sought for custody of my child under the Guardians and Wards Act, which is pending, my lords. The application filed by me. I filed in MC for restitution of conjugal rights. Then the other one which I did was a case of 420, my lords, in which, my lords, I say that her father-in-law was involved in siphoning off some funds of mine. This is how the cases are. Now, please notice the present complaint, which is subject matter of the challenge, my lords.
498, eh?
How? My lords would get that at page 23, annexure B, my lords, 8/10/2023.
In which petition, sir?
My lords, it's in WP 28591 of 2023.
Page?
Page 23, annexure B. 23, annexure B, my lords.
23, annexure.
Yes. My lords, this complaint is dated 8/10/2023, my lords. That the date of the complaint may be relevant to know the sequence which they mention in the complaint. My lords, 6th line in the complaint, my lords. Could I just read, my lords? When I start reading, my lords would have completed reading the whole complaint, my lords. So, please notice, my lords, their whole problem appears to be on 15th June 2020. My phone stopped working. My husband asked me to use his old iPhone till I got my phone repaired. Then comes his problem, my lords. She says what all she found in that phone. My lords would notice that portion. And then, my lords, on that basis, on the next page, 4th line, my husband, even after several reminders, did not give my investment and other important documents and belongings back. My husband threatened me on several occasions that he is very resourceful. Then, my lords, therefore, I request you to consider the criminal activities done by my husband and his friends, which involves various kinds of several criminal activities which need to be thoroughly investigated, and necessary action should be taken against my husband and his accomplice for causing serious mental harassment, mental and physical torture, harassment to my children, misappropriation of my investment, funds and financial resources, not giving me documents, asking for action to be taken. This is how the FIR for 498A 506 gets registered. Now, the relevant important documents in this sequence is, my lords.
No, don't tell me. Charge sheet is also filed?
Illa. My lords, page 25 only, if my lords notices the legal notice which came from them. Page 25, annexure C. 5/10/2020, my lords. When the settlement talks were all failing, my lords, at that point of time. And in which, my lords, paragraph 10, there's reference to certain WhatsApp conversations. My lords would get it, paragraph 10 at page 28. Then after putting in all those, my lords, paragraph 11, again WhatsApp conversations with another friend, my lords. And paragraph 12, the third set. So similar, all this so-called, what they would have obtained in the phone is what is there in this legal notice on 5/10/2020. And then in the legal notice, my lords, what is sought for may be noticed, my lords, at page 44, paragraph 20. My lords, what she's got in the phone conversation, but my lords, ultimately we'll have to see.
These were the messages in the
Message,
phone?
ultimately, my lords may have to see, my lords, in the context of cruelty by a husband or relatives of the husband, that context. My lords may kindly now notice page 44. What is it that they sought in 2020, my lords? Paragraph 20, in the light of the above, my client has instructed me to communicate in no uncertain terms that the marriage between my client and you has irretrievably broken down and there is no scope for reconsideration of the same. Paragraph 23, my lords, it would be advisable for you to terminate the marriage between and my client through divorce by mutual consent. My lords would get that at page 45. And right in the bottom at 45, that's the...
These were all found in the phone.
What was found in the phone? 2020 is what they say, my lords.
No, found in the phone later in 2023.
ಇಲ್ಲ,
No,
2020.
20 ಲೇನೆ.
My lords, 20 ಅಲ್ಲಿಯೇ ಅದಕ್ಕೆ ಈ ನೋಟಿಸಸ್ ಬರುತ್ತೆ, my lords, mutual consent ಗೆ 20. Now notice, my lords, the second notice, my lords should get at page 47, 15/3/2022. In which, my lords, at page 52 is what is it that they have sought in this notice, page 52, paragraph 13. They threaten, my lords, in case you don't give the remedy, then we will initiate criminal action against you. Page 52, paragraph 13 only. Then, my lords, settlement talks. During the settlement talks, exchange of settlement deed, my lords. The settlement deed, my lords, is at page 59, July 2023.
No, if these messages are true or found in the phone, which one will stay with you?
Not staying. That's fine, my lords. For my lords, could it amount to a case of cruelty, my lords? Now, point will be that, my
Yes,
lords,
that we'll see.
my lords, what
That
happened?
is for divorce proceedings, yes, it does amount to cruelty.
But for
But
the
then for
purpose of
498A,
498A, my lords. My lords, kindly notice after that the settlement. Post that, they've got it, notices are exchanged, they want a divorce. Kindly notice page 59, settlement agreement, which was exchanged between the parties. Page 59 only, my lords.
All right,
July 2023.
all right.
And what was at that time, my lords, under the settlement agreement, my lords, in the recital page 60, kindly notice 4,72 lakhs, page 60 only, my lords.
All right.
Then
ಆಮೇಲೆ ಏನಾಯ್ತು?
children, after this, my lords, after this comes another notice, my lords, at page 75, the third legal notice, 75. And this is sent to my friends, my lords. And they demand, my lords, please notice page 80, paragraph 19. Now this notice would be sent to my friends. Paragraph 19, this is what they would say, my lords. They have to pay damages and compensation of 2 crores. Then, as I mentioned, my lords, these proceedings that have commenced between the parties, my lords, the various proceedings, including the complaint which I gave against her. The complaint that I gave against her, my lords would get. The FIR is at page 82, my lords, 420, 406, 403, 109, 384 and 34. The relevant complaint in that, my lords should get at page 86, my lords. The whole complaint. Now, this is what is stated, and what 498A is what is stated in my petition, my lords. Now, my lords, even according to the whole sequence of event, my lords, 2007 marriage, 2020 she would leave the house, and these proceedings that are going on, 2023 would be this complaint which is given. Now, compare this with, my lords, what has happened in Achint Gupta's case, my lords. A similar complaint I'll point out, my lords, in that a similar complaint, my lords, because my lords, in Achint Gupta's also, they would say, my lords, it's a case
No,
of illegal relationship.
Looking at this.
Yes.
Prima facie, it is both of you are wanting to wash dirty linen and nothing else.
May I submit mine, if my
Oh,
friend
let
has
him
finished?
finish.
My lords,
Achin
I
Gupta,
will
yes.
just now, I pointed out the complaint, my lords. Please now notice, my lords, the judgment in Achin Gupta's.
That
I
I've
will
seen.
want to point out
It was the
complaint.
allegation of live-in relationship
My lords,
that would not amount to
alcoholic,
cruelty.
live-in relationship, cruelty in the form of assault
Yes.
and mental harassment. These were the same aspects, my
Yes,
lords, which
yes.
we had there.
Yes.
And what the court noticed there is, when the marriage took place, the children,
Achin
child out
Gupta
of
I've
the
seen,
marriage,
so don't
and
worry.
when the complaint came to be given. And then, my lords, the court analyzes that and says, my lords, in such a case, it will not be 498A. They fall back on Preeti Gupta, my lords, and says,
Yes, sir.
Lords has seen that, but just that relevant paragraph to show the similarity with the present
This is
case.
Pardiwala's judgment.
Out, absolutely.
2024 SSC online is 759.
Absolutely, my lords.
Mm.
The relevant paragraph in the analysis, if it is seen, my lords, the relevant paragraph, they would notice how 498A is misused. And
La-
then they would say, how
Para
it-
83 suggestions are given.
in Preeti
for the
Gupta case
no,
first,
that is there.
and then
In this
reiterate.
para 83,
How?
where they suggest changes,
They say, even though it was suggested earlier, under the new enactment,
it is
it
not
still,
been done.
it still stands the same. We are reiterating it. We are requesting the legislature to look into it, because this
No,
is what.
there is one protection now. Magistrate cannot take cognizance without issuing notice.
That is even now, my lords, that particular provision that has come, my lords. My lords, now,
Pre-cognizance litigation will
Notice.
commence.
my lords, if I go
That's the act, BNSS.
going to be
Pre,
such,
you see.
my lords, the idea of this new act is speedy, so that speedy justice, my lords,
Now,
proceeding should be
you,
fast.
before taking, now complaint. Complaint, sworn statement, notice.
Earlier.
No,
Earlier.
earlier.
ಈಗ.
Now, complaint, sworn statement, complaint, sworn statement, notice to the accused, hear him and then take
My lords,
cognizance.
ಈಗ complaint, on the complaint first send it.
ಇಲ್ಲ.
How,
Sworn-
my lords?
no.
Under the present BNS, as soon as a complaint
See,
is given.
section 233 of BNSS, sir. Subsection 1 of section 233 of BNSS. ಅಲ್ಲ, ಇರ್ಲಿ.
Sorry, my understanding is, my lords, now.
He is
when-
searching. I am
now,
telling you, subsection 1 of section 233.
my lords, sworn statement comes
Yes.
post taking cognizance.
Hmm.
Sworn statement comes post taking cognizance. Then you take sworn statement, issuance of process. Now, what they have done is, for the purpose of taking cognizance, you should give an opportunity.
That's what I'm
So
telling.
it is
A
pre-cognizance.
pre-cognizance natural justice is created.
Easy ಆಗುತ್ತೆ, my lords,
It
ಈಗ.
is for the first time.
And we are going to go back, rather than saying
Unheard-
speedy justice. Now, any complaint
Unheard in
given,
the-
all that the magistrate has to do is, I'm ordering notice. In every, they can't do anything else. Notice.
That's all.
After they come, hear them. I'm now satisfied. I'm taking cognizance.
I have granted an interim order interpreting 233 of BNSS saying sworn statement ತಗೊಳ್ಳೆ straight away notice issue ಮಾಡಿದ್ದಾರೆ to the, for appearance of the accused.
But sworn statement ನಂತರ ಬರುದು, my lords. I'm sorry, subject correction.
No, see that. Subsection 1 of section 233 BNSS. Notice at the pre-cognizant stage after sworn statement. Yes, sir. Anyway, that's not the issue here.
We'll have to now
Little digression.
we will have to now re-understand the new act and
No, nothing, only a few of
some
provisions.
sections are changed.
Otherwise,
I will just cross check that, my lords, because my understanding now is, my
sworn
lords.
statement first.
Then ಅಂದ್ರೆ cognizance ತಗೊಂಡಿರ್ತಾರೆ. Sworn
No.
statement is
Sworn-
post cognizance.
No.
Yes, my
That's the
lords.
procedure now that is changed. Sworn complaint, sworn statement, issue notice to the accused, pre-cognizance notice, then take cognizance after hearing the accused.
We become even more worse.
That's the act. That's
I'll
BNSS 233. Subsection 1 of section
I'll
233.
cross check it. Because my understanding was once complaint is given now, first you issue notice,
Yes.
get them, you have them? 1 minute.
Yeah, take it.
Yes, while taking issue notice. issue notice, record the sworn statement, then issue notice. Now it's going to generate, say, notice is not issued.
No, then generating lot of
Yes, yes.
proceedings here, my lords. 482.
482 na. 482 double agate.
That 233, my lords, 233.
233 is subsection 1 of section 233, correct? I guess 233.
Certainly. Stay the proceed. 233 is staying, my lords. It's similar to that 210. 233.
No. 200 of CRPC is 233 now.
No, my lords. 233 is 210.
No.
210 is 233. My lords. So
Two,
far
sir.
as
Section 200 CRPC is 233 now. ಅದು ಆ book ಅಲ್ಲಿ ಗೊತ್ತಾಗಲ್ಲ ನಿಮ್ಗೆ.
ಅಲ್ಲ ಇದೆ ಚಾರ್ಟ್ ಇದೆ ಮೊದಲೇ
Comparative chart ಅಲ್ಲಿ.
they give the CRPC in comparison with BNSS.
200 is 233. Correct.
No, my lords, 200 is 223. 200 is
223.
223. My lords, 210 is 233. 200 is
223.
Oh,
maybe, yes.
223, my lords.
Subsection 1 of section 223.
So
No.
what was? My lords, on that aspect, I will just examine it,
No.
my lords.
Sworn statement, complaint, sworn statement, notice,
no
notice
test.
to the accused, precognizance.
I was under the
223,
impression-
not 233.
223.
Yes.
Anyway, my lords, I'll
That
just.
2333 mistake. 223.
223. 233 will be
No,
210.
it's all right. 223.
And
correct.
then check my. My lords, so in my
Subsection 1 of
respectful
section
submission,
223.
my lords,
Yes.
my respectful submission, so far as 498A is
That
concerned,
we'll see.
my
Yes,
respectful
madam.
submission
Yes.
on this.
My lords may kindly see page 23 of the same petition, 28591. I just want to read out the contents of the complaint. It's just a 1.5 page complaint to page 23 about the 5th line. My husband was always very abusive and humiliating. He used to humiliate me in public and private moments. He forced us to sleep on the floor for several years. On 15th June 2020, my phone stopped working and my husband asked me to use his old iPhone till he gets his phone repaired. When I tried to use that phone, I came across several messages, WhatsApp chats, messenger chats, and images and photographs, which were highly intimidating and humiliating and a shock for me. My husband, who had been treating me with cruelty and was not giving any time, attention, and respect, was also humiliating and disrespecting me, was actually living a dual life with 3 of his friends, namely so-and-so. All these men were involved in soliciting prostitutes, pervert discussions and representation of women, minor girls and their own daughters and sisters, and how to abuse them sexually. I was shocked to see that my husband had shared several of mine and my children's photographs, including some objectionable and intimate chats with his friends. With one of his friends, he was systematically guiding how to sexually exploit me by making me drunk and take advantage of me. Not only that, he had perverted talks with so-and-so. My husband, along with these 3 culprits, was involved in fulfilling his untamed and pervert sexual desires and antisocial activities. Not only this, my husband used several escorts for his friends and negotiating on the amount of services. My husband had discussed about me I'm not able to read it, in a humiliating manner, and I was the object of their pleasure. I was being forced and pressurized by my husband to act and indulge in group sex and other activities with his friends. I refused all of these, and this put me in a mental trauma and shock. When I confronted him and his family told him to shift me to Bangalore and requested that I shall not take any action for the sake of their reputation and image of both families. I was totally devastated. I'm financially dependent on my husband, as after marriage, I was not allowed to work and had to take care of family responsibilities. So-and-so, my lords. My husband has misappropriated my funds and investment. My husband's family has kept on assuring me that they will get everything sorted, but they fooled me to get me to stop taking any action. I have been threatened regularly by my husband and his accomplices for life, safety, and well-being of myself and my children, etc. Now, my lords.
Now, please go to 498A.
Yes.
Read
No,
498.
my lords, just for a moment, I'll come to 490. Kindly give me one indulgence. I have submitted a memo of chats which was
So,
given
I've
to the
seen that.
police. No, 2-3 things where, in fact, just 2-3 pages, I will just refer. I will not take more time. If my lords may just see that the memo filed.
Yes.
memo of chats. There's a compilation. but
Yes,
it's a separate
I
memo.
have it, yes.
Yes, my lords may just see page 9. Page
Hmm.
9, some of the chats are about, he says, with his wife.
Hmm.
Then my lords may see page 27. Page 27, where he is talking about,
No, he's talking to another man.
yes, but about on page 9, he's talking to another man, but about me at 6:09:47 p.m. Anything with wife. Then he says all
No,
those remaining chats. I don't want to say it.
No problem. You
yes.
can't read those.
Yes, I'm not going to read it.
They are unreadable.
Yes.
But go to 498A.
Yes, just to, while my lords are there, my lords may see page 27.
Hmm.
Page 27, he is talking about page 27,
Hmm.
95803, known person, 959. These are all cousins and relatives, where he is talking about sexually abusing them, and even about me at page 16. Kindly see page 16. Page 16, again, the 4th or 5th line. Then he has sent at page 21, he has sent actually my photographs. Now, my learned friend can say, oh, he is chatting with somebody else.
No, that's all right. 498A.
Yes, 498, I will read out.
Yes. Other things maybe, but 498A.
Yes, my lords.
Yes.
In fact, 498A, kindly give
There
me-
are two instances of 498A.
Yes, both
Which touch up what is cruelty is also
Yes.
said. Yes.
sorry, 498.
Yes.
Whoever being the husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and also be liable to fine.
Cruelty is defined there only.
Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical of the woman. Now, my lords, I want to pause here. What is an injury to the health of a woman, physical or mental? My lords, here, if she has found out that he is in fact leading a dual life, he's having sexual relations with other men, he is having sexual relations with other women, he is using me as a bait for other men. He is saying that he will sexually assault other women, and there is proof in these chats that he has actually done that. And I ask myself, is that not a danger to the mental and physical health of a woman when she finds out this? And I have stated that in my complaint. Now, my lords, my submission is the complaint has the ingredients of the
498A.
Yes.
All right.
My lords, my submission is, how do we look at physical or mental cruelty? My lords, I want to ask myself that. Does first of all,
Yes.
this has been in my complaint. I have said not only have I seen these, have I brought this to the attention of him when I got these chats. Thereafter, I have been threatened and thrown out of the house. Kindly see the ingredients of my complaint. In order to not raise this,
yes.
I have been threatened and thrown out. Now, my lords, is this not, if I ask myself, mental health, danger to life, limb or health, whether mental or physical? What is a danger to the mental health of a woman? My lords, it is also an opportunity for us to ask ourselves that. At least I use this. Does it mean that a man who does not take any physical harm, if he does not physically assault a woman, then what would be a mental assault to a woman? Or what would be mental cruelty? If we take a view that this is not mental cruelty, my lords, we will be diluting this section with great respect. We would be diluting this section.
Interpretation of that by any court, give it.
Yes, my lords, I will submit it. In fact, it would be, my lords, I have given a submission of judgments. But may I, before I get to the judgments issues, may I just first finish the documents?
Yes.
Thereafter, my lords, I filed this complaint on 8/10/23.
Hmm.
Because immediately after filing this complaint, after the chats and all the harassment was happening, when I raised several legal notices, the families with my lords, both families are extremely well-known families, and there was great pressure on me not to do anything, saying that we will settle, we will settle, we will settle. Please keep quiet, it will be handled. I'm thrown out of the house, which also I have stated, and no settlement is coming forward. In fact, what my friend read out is a settlement of money which is already given to me, for which he has now filed extortion. Absolutely no settlement
So
is
that
there.
extortion is not.
Yes. Thereafter, having no other option, I file this. Now, my lords, immediately after I file this, kindly take, my lords, the next petition. I filed this on 8/10/2013. And my lords, the complaint by him is filed on 25/11/23.
No, that's all.
Yes.
Extortion complaint, you don't worry.
Yes.
You concentrate on 498.
Yes. I would like to point out the extortion complaint because no extortion is made out.
I told you. No
Yes.
extortion. Yes.
Grateful. Now, my lords, I want to, then let me submit the decisions. My lords, I have,
There's no compilation here.
I will. You have the compilation. My lords, can I hand over?
Have you given it?
I'll
That's
just
all.
give another copy to them. Have you served? Do we have another? Just give, no? I have my soft copy. Yes. My lords, initially.
Extortion, don't worry.
Yes, I'm not.
Don't
covering
labor on
it.
that at all, madam.
Yes. My lords, I am not covering.
Eating, extortion, don't.
I will not
labor
cover
on that
those.
at
Though I have covered it, I will not read it out.
Yes.
Now, my lord.
I just want that interpretation in a 498
mental
offense, that cruelty of this kind would also become a cruelty.
May I make one submission? I have submitted one judgment on 498A. I will
Which is
refer
that?
to that, to Neelaveni.
All
But
right.
on the specific question that my lords have asked on mental cruelty coming under 498A, my lords may reserve it. I will submit those decisions. So I will not take more time, but I want to give my lords.
You
those
know, I'll
decisions.
reserve it.
Or my lords may give a day's time. So I will give those decisions.
Perfect.
Ultimately, if my lords are dictating, I will give those citations.
Yes.
So I will-
Because your, this Neelaveni versus state
Yes,
is considered in Achin Gupta, Kashkan Kaushal, Preeti Gupta.
yes.
It considers this judgment also, all
Yes.
three. And they have said, we should read Achin Gupta and then try to distinguish that.
My lords, we are here in Neelaveni. They may have
No,
considered.
much water has flown after that.
No, my lords, water may have, with great respect, 498, the interpretation has not changed. What my
It
friend.
has. That's the reason I told you. You should read Achin Gupta, Preeti Gupta, Achin Gupta, Kashkan Kaushal. Insofar as husband is concerned, it is Preeti Gupta and Achin Gupta. You want family members, it is Kashkan Kaushal.
Here
So
it is,
those have completely diluted the earlier judgments.
my humble submission, my lords, is that Neelaveni has not been either diluted or set aside in any way. Yes.
Not set aside, diluted.
Yes.
If the Supreme Court has subsequently, after considering it, the bench of the same strength has written something else, we'll follow the subsequent.
My submission on Neelaveni is one submission. Neelaveni says very clearly that where averments are made out, to what extent? May I just read that?
Contents of the complaint are made out,
Yes.
washing under 482 would not arise.
Yes.
But whether the ingredients in the
Of
complaint are made
mental
out,
cruelty, my
that
lords
is,
asked.
that's all.
My lords asked me.
Because
on
there
mental
is
cruelty under
no
498.
harassment on demand of dowry. It is only mental cruelty.
Mental cruelty under 498A, my
Yes,
lords,
that's
that
right.
I will give my lords specific decision, since my lords specific
Yes.
question is that. My submission is even as Achin Gupta, that question is not
It
the.
is.
My lords, I will
Because
submit.
there also the illicit relationship was the allegation. That was in the complaint.
Yes, but here
Would
my.
not amount to 498A is what is said. You may have to read that and
No,
try to
I'm
distinguish.
familiar with that. I'm familiar with that. But the illicit relations, my lords, there are 2-3 decisions which my lords are familiar with. Illicit relations may not come under 498A is one set of decisions.
Because in
What
that-
is mental cruelty? I
Yes.
want to make that submission.
There are, you should labor on it.
I will.
You did not give me those in the Jim Corbett case also.
I will give that. That I know
I-
which my lords are submitting. I will allow me a
So
day's time.
you give me.
My
No,
lords may give me
I
a
have
day's
myself
time.
found out.
I will also
They
give
are a
that
part of that judgment, but
grateful.
you
My
should
lords,
give me
on
some-
mental cruelty, the illicit relations with someone else versus over here mental cruelty to the woman, where her name is being used. He is not, whether he has illicit relationships with other women, that is not the question. How he has used her, what he has been, what these chats implicate, I will submit. Give me a day's time, my lord, so that my lords can pass a considered decision.
Otherwise,
My lords, I'll only assist my lords. Of course, my lords will pass a considered decision. It is only to assist my lords.
yes,
My lords may keep
then
it.
it's fine saying that will not pass any
No,
considered
no,
decision.
that is taken for granted that my lords are going to pass a considered decision. We have no doubt.
One
about
aspect could I just point out, Neelaveni's judgment, my lord.
Yes,
My lords, paragraph 3 and 4 makes it very clear. Neelaveni's judgment, according to first information report, when the appellant was pregnant, on scan it was found she's carrying a female fetus. Her husband and family members harassed her, insisted to abort the
no, no,
child.
it's right.
And then please notice, he marries.
No, no, why the senior counsel is
Mental
citing, no,
harassment.
no,
is level.
citing Nilaveni is, when the complaint makes out offense under 482, you should not quash.
Here, that's why
why it is
Neelaveni,
referred to it.
it made out. Neelaveni, it made out 490. And my lords, I'm sorry, my lords. I just had a quick look at that provision, my lords.
423.
Yes, my lords. My
Sworn
lords,
statement first alva.
it is, kindly notice, I'll just point it out. Earlier, how it was 200, my lords. 200 only. A magistrate taking cognizance of an offense on complaint shall examine upon oath the complainant and the witnesses, and thereafter to
That is
not
sworn
issuance.
statement, yes.
Earlier, my lords.
Mm.
So what they do is first you take cognizance, post it for sworn statement, take sworn statement, apply your mind whether it's a fit case to issue process, because process
204.
204. This is how it was. Now kindly notice the change that has been done now. Same, they maintain the same words, my lords. They
But
say
notice to be issued before taking cognizance.
before taking cognizance.
That's what I said.
So which means sworn statement is later.
No, no.
My lords, that's the, it's like, I'll just point, just notice this, my lords.
Let's see. Although when it comes in a case, we will interpret.
Because I think
There is one
sworn-
pending, we will interpret. it.
Because
Yes.
sworn statement always is post cognizance, my lords.
Well
It
said.
can never be before cognizance. Because
So,
my lords,
now sworn statement will be after hearing the accused.
that's it. Cognizance is after hearing the accused. Now, before taking cognizance, you have to give an opportunity to the accused. Whole thing is going to become, sorry,
It's going double litigation now.
it becomes very tough. So I really don't know.
No, but there is a reason for doing it. So many frivolous cases. So many frivolous cases being registered left, right, center. That's why it is brought in.
But now what's going to happen to speedy justice?
That will.
Who will
Now,
notice the
now
complaint ಅಲ್ಲಿ?
no, now the jargon has to change because of these frivolous cases. Not the speedy justice, but needy justice. Yes.
My lords may take it on Monday, top of the board. I'll just submit those decisions.
No, I'll take it on 20th.
20th.
By then you give whatever you want.
Yes.
List the matter on 21st for further hearing at 4 p.m. Yes.
Obliged. Their interim orders in both the matters.
Interim orders subsisting in both these cases shall continue to the next date of hearing,
21st, my lords.
21st. Only on that, madam.
Yes, yes. On
Mental
that,
cruelty 498.
yes.
ನೀವು ಕೊಡಿ.
The sequence, latest one, I have to see all the ones earlier to it and put it together. ಎಲ್ಲ cover ಆಗಿದೆ.
Yes. If you don't have judgments, I'll give my judgment. Yes. Next. Post immediate left to service of notice upon the second respondent. Interim order shall continue to the next date of hearing. Idre. 59 ಆಯ್ತಲ್ಲ. Yes.
323, 324, 307, please.
307.
307.
Settlement.
Settlement, at most attracted 324, please. 65. Is rendered.
307.
Please.
Where is the wound certificate?
Wound certificate is page 63, please. Third. Simple injuries, 63.
Simple,
and out. 63 and 64.
ಯಾರು ಇವರೆಲ್ಲ ಅಕ್ಯೂಸ್ಡ್?
Accused and injured.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
I represent the.
Yes, Jagdish.
asking for 62.
62 ನ
So
62 ಯಾವುದು?
91 application ಮೇಲೆ records have been kept here. Trial court is. They're asking for call records of 2015 in 2024, which is not.
ಓ ದಟ್ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ಲ ಅವರು ಹೇಳಿಲ್ಲ ನಿಮ್ಗೆ? ಇಲ್ಲಾಂದ್ರೆ 13th ಹಾಕ್ತೀನಿ. 13th ಹಾಕಿ ಮಾಡಿ. ಎಸ್ ಹಾ ಇದ್ರೆ ಹೇಳಿ. 307
307.
but simple injuries. Lakshmi Narayan,
Right, ma'am.
class 5 of that judgment. The petitioners are before this court. Charge sheet ಆಗಿದೆಯಾ? Calling in question the proceedings in SC 1058 of 2023 registered for offences punishable under so and so. The petitioners are accused who get embroiled in a crime which arose out of an alleged assault of the complainant by these accused. It becomes a crime in after the registration of the crime, the police file a charge sheet for offence punishable under so and so. Since the offence was the one punishable under 307, the matter is committed to the Court of Session and is presently pending as SC 1058 of 2023. During the pendency of the proceedings before the concerned court, the parties to the list have resolved the dispute amongst themselves and have drawn up certain terms of settlement. The terms of settlement would read as follows. Joint affidavit ಹಾಕ್ಬಿಡಿ 2 page ಇಲ್ಲ. The issue now would be whether in the teeth of the offence punishable under section 307 of the IPC, the application seeking compounding of the offence could be accepted and the proceedings closed against the accused. In an identical issue, the apex court in the case of Lakshmi Narayan versus ಎಲ್ಲಿಯದು ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಮಾಡಲ್ಲ ಸುಮ್ಮನೆ ತರ 2019 5 SCC page 626 ಇರ್ಬೇಕು ನೋಡಿ, ಅದರಲ್ಲಿ paragraph 12 and paragraph 17 you extract. So the apex court directs the high court which seeks to compound the offences even when the offence punishable is section 307, what should be looked into is the wound certificate. If the wound certificate would depict that the wounds inflicted are simple in nature, the matter can be closed by a settlement. In the case at hand, the wound certificate is as follows. Page
63 and 64.
63 and 64. ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ ಮಾತ್ರ ಹಾಕಿ ಪೂರ್ತಿ ಬೇಡ. The injury sustained by the complainant is said to be simple in nature. Therefore, the wound certificate would depict that the injuries are simple in nature. In that light, there would be no impediment for this court to close the proceedings, accepting the settlement between the parties for the aforesaid reasons. So disposed. Yes, next.
Acha.
Six to 70, adjourn 71. One.
Sub-registrar, this allegation is 420, 468.
A respondent here. Case Panap. Heard the Learned Counsel Rajshekhar appearing for the petitioner.
Stay.
Huh?
Stay there.
Pottu. No representation on behalf of the petitioner, respondent, second respondent complainant. List after 2 weeks, interim, 3 weeks, interim order subsisting shall continue till the next date of hearing.
P group 73.
Lordship, appearing for the petitioner, it's a disproportionate assets case, your lordship. What happens is that
against the petitioner, a previous crime was registered for the offense under section 7A. Now a trap was laid, the trap was unsuccessful.
Or trapality, I have granted stay, I guess.
Yes, your lordship, that's an interim order.
Yes. List after 2 weeks, interim order subsisting shall continue till the next date of hearing.
Please, your lordship.
Yes, next. Heard so and so ಮಾಡಿ, respondent absent ಅಂತ ಹಾಕಿ ಆಮೇಲೆ ಮಾಡಿ.
74.
My lord, I am the petitioner in this case, my lord.
Why are you on VC?
My lord, I was just a bit, to be honest, I was confused with the cause list today, my lord. I really apologize, my lord.
No problem. When do you want?
My lord, this case has not reached a couple of times, my lord. Can I
Interim order is
request?
there, sir.
Yes, my
Yes.
lord, yes, my lord. Yes,
List the matter on 29th.
29th, yes, my lord.
Yes, 29th. Interim
Yes,
order
ma'am.
subsisting shall
There is
continue.
the other case, special case also on that date, sir.
Which is that?
That's
ಇವತ್ತಿದೆಯಾ ಅದು?
ಇಲ್ಲ my lord, 29th ಅದು ಇದೆ, ಅವತ್ತೇ ಬರ್ತೀನಿ.
ಆಯ್ತು, ಅವತ್ತೇ ಬರ್ಲಿ. Yes.
Okay, much obliged, my lord.
Yes.
My lord, sir, serial number 71, my lords. I'm sorry.
71 is urgent. ಪೊನ್ನಪ್ಪ not present ಅಂತ ತೆಗೆದ್ಬಿಡಿ.
My lord, sir, there has been a impersonification they have done before the lower court and
KS ಪೊನ್ನಪ್ಪ ನೀವಾ?
I got everything yesterday.
71
Please,
KS
ma'am.
ಪೊನ್ನಪ್ಪ ನೀವಾ?
Please, my
Class
lord.
list ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
71, my lord. Respond number 2.
Not present ಅಂತ ತೆಗೆದ್ಬಿಡಿ. Will ಯಾವತ್ತು ಹಾಕಿದೆ ಅದು? List after 3 weeks, yes.
I request for a date, my lords.
Vacating stage.
Because they were impersonified a person before a lower court. It is the only reason.
ಅಲ್ಲಿ list on 4th September. Yes, next.
Grateful, my lords.
25 adjourned, 76 reporting settlement, 76.
ಏನಿದು? ರಾಧಾಕೃಷ್ಣ. Offense.
364A and you are relying on your lordship.
Oh, ಇವ್ರದ್ದು.
And they are in custody from 15 to 21, my lord. And almost.
ಏನ್ ಮಾಡೋದು?
364, my lord, evidence also is given a full evidence.
ಅಲ್ಲ, he
before
is the
trial.
victim.
Correct, he is given full supporting evidence before trial court.
ನಾನು ಸುಳ್ಳು ಹೇಳೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ದೆ ನಾನು first ಅಲ್ಲಿ. ನಂಗೆ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. I suffered the damage.
Trial conclude ಆಗಕ್ಕೆ will give direction.
Dagala, I request you lordships kindly, this fact take into consideration. They are in custody from 15 to 2021.
15 to 21.
21.
364 ಅಲ್ಲಿ ಮತ್ತೆ ಕಸ್ಟಡಿಲೇ ಇರ್ತಾರೆ.
Similarly placed circumstances, I have given one order. Lordships may consider. I request you lordships.
It has a death penalty.
Death penalty, that's what.
Even that, the which your lordships has considered, 364A is there and 395 is also there. I request you lordships kindly. They are relying on the apex court decisions.
I know, sir. 364 ಐತಾ ಇದರಲ್ಲಿ?
ಅದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ತಾವು ಮಾಡಿರೋದ್ರಲ್ಲಿ ಇದೆ.
ನಾನ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ.
ನಾವು ತಾವು ಮಾಡಿರೋದ್ರಲ್ಲಿ.
ಅಲ್ಲ, that is following on Punjab and Haryana judgment.
True, man.
364A.
395, 364 ಎರಡು ಇದೆ ಸ್ವಾಮಿ.
Yes, sir.
Considering the engaged.
ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರ ransom?
ಅಲ್ಲ ಕ್ಷಮಿಸಿ, ನಾನು ನಮ್ಮನ್ನ ಒಳ್ಳೆಯರು ಅಂತ ನಾನು ಹೇಳಲ್ಲ. With great respect to my learned friend, he has suffered. And now.
I just thought that maybe my son's friends ಅಂತ ಕಾರ್ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟೆ. Then he was bandage ಹಾಕೊಂಡು ಇದೆಲ್ಲ ಇದ್ರು. Then
ಬ್ಯಾಂಡೇಜ್ ಎಲ್ಲ ಹಾಕೊಂಡ್ ಬಂದಿರಾ?
ರಕ್ತ ಸುರಿತಾ ಇತ್ತು. So I just thought of helping them.
I request.
But since
Such people should remain in custody.
ಮತ್ತೆ ಬಂದದೇ ಮಾಡ್ತಾರೆ. At least ನಾವು
ಮತ್ತೆ ಬಂದ ಮತ್ತೆ
ಇಲ್ಲ
ಬೇರೆ ಏನ್ ಮಾಡ್ತಾರೆ?
put on terms.
ನಮ್ಮಲ್ಲ ಈ ವಕೀಲರೇ ಬರ್ದಿದ್ದಾರೆ.
ಡೈಲಿ ವೇಜ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಸೇರ್ಕೊಂತೀರಾ?
ಅಲ್ಲ ಇಲ್ಲ
ಮತ್ತೆ
ಐ ರಿಕ್ವೆಸ್ಟ್
ಅಗ್ರಿಕಲ್ಚರ್ ಹೋಗ್ಬಿಡ್ತೀವಿ ಊರಿಗೆ ಅದು ಇದು ಅಂತೆಲ್ಲ ಪೇರೆಂಟ್ಸ್ ಎಲ್ಲ ಬಂದು
ಒಳಗಡೆ ಇದ್ದಾರೆ. Now they have reformed. I think they have understood what is the conditions. Placing on reliance of this on court order only I am requesting.
ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ಮೀ ಇಸ್ ಎಲ್ಲ ಮನೆ ಹತ್ರ ಇದ್ದಾರೆ, ಎಲ್ಲ ಪೇರೆಂಟ್ಸ್ ಬಂದು ಮನೆ ಹತ್ರ ದಿನ ಹತ್ಕೊಂಡು ನಿಂತಿರ್ತಾರೆ. ಸರ್ ಐ ಸೆಡ್ ಓಕೆ
364 ಇಲ್ಲಿ see in this complaint there was no ransom. ಈ ನಾನ್ ಮಾಡಿರೋ ಕೇಸಲ್ಲಿ ಇಲ್ಲಿ there is definitely ransom in this case.
ತಗೊಂಡಿದ್ದಾರೆ ಮನಿ ತಗೊಂಡಿದ್ದಾರೆ.
ಎಷ್ಟು?
15,000 16,000.
ಅದಕ್ಕೆ ಬ್ಯಾಂಡೇಜ್ ಎಲ್ಲ ಹಾಕೊಂಡಿದ್ರ?
ಇಲ್ಲ, ಜಸ್ಟ್ ವೇಟಿಂಗ್ ಫಾರ್ ಹೆಬಿಚುವಲ್ ಅಂತ ಹೇಳಿ ಅವರೆಲ್ಲ ಇದು ಮಾಡಿದ್ರು. ಒಂದು ಒಬ್ಬೊಬ್ಬರ ಮೇಲೆ 5,000 ಕೇಸ್ ಇತ್ತು. So ಹಾಗಾಗಿ
This condition, they are in custody.
Maybe, sir.
Sometimes my lord, with one permission.
They are bound to be there if it is 364A.
Sometimes, my lord, in the case of this type, suppose if the appeal is filed, 3.5 to 4 years will be sufficient antane, this court will hurt. In such a
at least now they can be put on
already-
terms and then conditions ಹಾಕಿ ಬಿಟ್ಟು.
What terms now? ಇನ್ಮೇಲೆ ಇದು ಮಾಡಬೇಡಿ ಅಂತನ?
We leave to the Sun court, my lord, that conditions cannot be imposed. That is.
Don't do this ಅಂತ.
That is true.
Because
He says he has multiple cases, the history also. if they are-
ಅಲ್ಲ ಅದೆಲ್ಲದ್ರಲ್ಲೂ ಹಾಕ್ಬಿಟ್ಟು ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮತ್ತೆ ಇದ್ರಲ್ಲೂ ಹಾಕ್ಬಿಟ್ಟು ಆಗಿ ಬಂದ ಕೇಸ್ ಏನು ಆಗಲ್ಲ ಅನ್ಕೊಳ್ತಾರೆ. ಅಟ್ಲೀಸ್ಟ್ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಇದು ಓಪನ್ ಆಗುತ್ತೆ ಅನ್ನೋದೊಂದು ಹೆದರಿಕೆ ಆದ್ರೂ ಇರುತ್ತೆ ಅವ್ರಿಗೆ.
ಮತ್ತೆ
That's so kindly.
ಇಲ್ಲ, and then
Plus point another, they are in custody from 3.5.
maybe, sir, they are bound to be there. The offense is that.
Your lordship has considered in one.
No,
Maybe
that
this
is why I said ಓದ್ಬಿಡಿ ಇದನ್ನ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಂದು ಅಕ್ಷರ ರ್ಯಾನ್ಸಮ್ ಬಗ್ಗೆ ಇಲ್ಲ ಅಲ್ಲಿ.
And relying on the.
I have quoted the complaint also here. Yes, ನೋಡಿ. So you should get me 364A, let me see. ನೀವೇನ್ ಬರ್ಬೇಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. You carry on with your work. We'll see if it is settleable, not today, but on 20th.
privileges.
ಬೇರೆ ಜಡ್ಮೆಂಟ್ ಇದೆಯಾ?
ಅದು ನಿಮ್ದೇ ಇದೆ ಸರ್.
ಅದು ಗೊತ್ತು, ಅದರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇರೆ ಇದೆ.
364 ಅಲ್ಲಿ ಇದು ಮಾಡಿರೋದನ್ನೇ 384 ಅಲ್ಲಿ ಇದು ಮಾಡಿರೋದು.
384 extortion.
ರಾಬರಿನಲ್ಲಿ.
Extortion.
ಅಲ್ಲ, I have given that judgment also. Robbery case ನಲ್ಲಿ also found guilty for offense, and so apex court has given benefit of this thing.
That is 395.
These also 395.
399, 402.
I have placed that, 394.
Let's see.
And in on 326 ನಲ್ಲಿ your lordship has considered.
That will see. Let's see.
Then
Yes.
409 ಅಲ್ಲಿ coordinate.
Right,
bench of
nodu.
Supreme Court has
Yes,
considered.
yes. Next, don't call,
Privilege.
madam.
Make one request, madam. ಅವತ್ತು ಅವ್ರು ಇರ್ಲಿ, ಅದಕ್ಕೆ ಯಾವತ್ತ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್.
ಅವ್ರಿಗೆ ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತೀರಾ? ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ.
Pathetic
He
condition.
has suffered and he has,
ನಮ್ ಕೈ.
no, despite he has suffered
That is true.
and he has come forward to settle it, that is enough.
That reason only I openly
ಮತ್ತೆ?
submitted that I will not say that my clients are up to.
We'll see. Yes.
30 more matters orders. Number 1, Prativandana, BA.
ಇವರು ರೋಣ್ ಅವರಲ್ಲಿ ಅದೇ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಒಂದು 5 ನಿಮಿಷ
He said he'll come.
ಬರಕ್ ಹೇಳಿ. Yes, madam.
We're filing a memo of withdrawal, my lord. The present petition was filed for the quashing of FIR.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿಲ್ಲ, your honor. So kindly,
ಏನಾಗಿದೆ?
charge sheet has been filed, my lord. So kindly withdraw this petition and
Yeah.
give liberty to file the fresh petition, my lord.
You are Ramesh Samson's colleague. In terms of, yes. Next,
With
Number
liberty to file fresh suit.
madam.
With liberty to file. fresh
Yes,
suit.
yes.
Gratefully.
Number 2, please proceed.
That's right, list ಅಲ್ಲಿ. ಹಾ. Yes, sir. ಇದಕ್ಕೂ ಕೇಸ್ ಹಾಕ್ಬೇಕಾ ನೀವು? ಯಾಕೆ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ?
No, is in police custody.
ಇಲ್ಲ ಏನ್ ಮಾಡಿದಾರೆ ಇವರು? ಐ ಜಸ್ಟ್ ನಾಟ್ kindly take not the synopsis.
Police
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ನೋಡಿ. your lordship may kindly see not the order sheet in ECIR, not at page 271. 271.
ಹಾ.
Your lordship may kindly come to not page 272. So this is on 22/7, 272 not para 3. The investigating agency has also filed an application. Lordship's got not that. 272, not para 3. The investigating agency has also, that is not ED, has filed an application at 267 under section 19 of PMLA requesting the court to issue body warrant as against Mr. So and so with UTP number so and so. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ನೋಡಿ, your lordship will find not on the next page 273. Peruse the application, grounds made out and satisfied with the reasons assigned by the investigating agency. Further, provisions of 267 of CRPC would indicate that necessary orders of body warrant may be issued by the court for answering to a charge or for purpose of proceeding. Hence, it would be appropriate to issue necessary order for body warrant, directing Chief Superintendent of Police to produce him on so and so on 23/7. Then kindly come to my lord. On 23/7, he was not produced. Next, page 274, my lord. Para 3, show cause notice was issued to the Superintendent of Central Prison. Not meanwhile, but your lordship may kindly come to not page 25.
Well, 1/8/2024 order is directed to issue necessary body warrant.
Body
Jail warrant shall be served through the investigating officer, so and so.
ಹೌದು ಅದೇನಾಗಿದೆ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆನ್ 2/8 ನೋಡಿ your lordship will find
2/8.
1/8 ಗೆ ಬಾಡಿ ವಾರೆಂಟ್ ಆಯ್ತು.
ಹೌದು.
227 at page 227 your lordship will find.
Yes.
ನೋಡಿ crime 109 of 24. Not last line not of this 227. The crime 109 not is a state case. Last line directed to send back accused to JC in original case. This happens not on 2/8.
Page 227.
227 ಅಲ್ಲಿ last your lordship will find
Demand application so and so.
so and so.
IO is directed to send back accused to same accused aidu.
Same accused.
JC in original case so and so high ground body.
Kindly come to the next line, not
Yes.
intimation to the concerned. The Director of Enforcement has filed intimation and taken on record. I go to the court and intimate the court that there is already a body warrant issued by the higher court, not in ED. Not what they do, not the very state agency, not now kindly come to page 25. So as on 2/8, not the accused is in judicial custody. As on 2/8, body warrant is in existence, not issued by the ED court. Now what they do on 3/8, not your lordship will not find at page 25. Not the state agency, not again files, not in another case, crime number 202. The IO has filed accusation to issue body warrant with escort. We use offices hereby directed to issue body warrant as prayed, call on 3/8. By this happens on 2/8. By then, the body warrant issued may not by the special court, it is already in existence.
Very neat ploy to get over ED.
Not now, this is the third, this is the fourth case. I am told they have another 8 cases pending with the same issue.
2 more cases.
Now that the body warrant has been issued by ED court, that's already pending. Not they can't defeat it like this.
How can a PC order be passed?
That's already intimated to the court.
Allah, the issue, my lord, is that when the first order was passed, they did not inform the court that he is in police custody.
Now you know it.
Allah,
Yava police custody. They were not in police custody.
no, he was in our police custody.
No. He was sent back to judicial custody.
No, this is on 2, he's talking about 2/8.
Yes.
But the first order which. my
That's
lord
all
is
right.
talking
Police
about-
custody is 3/8.
No, 2/8 ವರ್ಗೂ ನಮ್ ಕಸ್ಟಡಿಲಿ ಇದ್ದ.
ಮುಗಿತಲ್ಲ ನಿಮ್ 2/8 ಗೆ.
2/8 ಗೆ ವಾಪಸ್ ಜೆಸಿಗೆ ಹೋಗಾಯ್ತಾ ಇಲ್ವಾ?
Correct.
JC ಗೆ
Next
ಹೋದ್ಮೇಲೆ
case
ನಮ್ದು
2/8 ಗೆ ಜೆಸಿಗೆ ಹೋಗಾದ್ಮೇಲೆ there is no PC.
ಅಲ್ಲ next day.
Next day.
ಅವಾಗ ನಮ್ದು EC pending.
ಅವಾಗ already there is an order.
What we have done, my lord, is.
Sir, as on the date of the order, that is on 1/8,
Yes,
information illa, we'll accept it. No problem. Body warrant is issued for production before the, in the ECIR. Now the next day he is sent back to judicial custody.
correct.
When this is communicated, he is again taken to police custody. Where is it?
ಅಲ್ಲ, we have to investigate and we have taken.
ಈಗ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
He is in custody, police custody.
Will direct his release now for.
ಅಲ್ಲ,
I will hold that police custody is illegal.
he is in custody till 12th. Let them take it after 12th.
He is in custody, police custody is illegal on the face of it.
At my lord, that.
That deliberately have taken police custody, any special treatment.
ಕೊಡ್ತೀವಿ, ಕಾಪಿ ಕೊಡ್ತೀವಿ, ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡ್ತೀವಿ, ಎಲ್ಲ ಮಾಡ್ತೀವಿ, ಕೋರ್ಟ್ಗೂ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀವಿ. ಸೇಮ್ ಏಜೆನ್ಸಿ ಕಮ್ಸ್.
This is not.
No,
ಏನ್ ಈಗ ಇಂಟ್ರೋಗೇಷನ್ ಮಾಡಬಾರ್ದು ಅವರು ಅಂತ.
ಅಲ್ಲ, we have no problem, but your lordship may see, it is not that we have, all the accusers we have done it, it is not that we have done it only for this person. All the accused who were involved in those cases, we have all these cases, one after the other, we have taken to the custody.
Yes, when do you want his custody?
Not today, tomorrow.
12th.
I'm ready.
Why 12?
Isn't middle of my lord, we have recovered, we have to recover another 30 plus crore rupees. We have recovered 49 crore rupees. We have to recover 30 plus crore rupees. We are in the, he is the main person to recovery of this money. We have now so far.
But today he is in police custody.
No, he's already not taken 14 days, one case, 14 days, another
No,
case.
true. Now today is in police custody.
Please.
Whether this court could direct release of release.
Now,
release of
body
police
warrant, fresh
custody.
body warrant has already been issued again by the court.
When today?
Today in the 3 o'clock.
Till 12th, I have been told, my lord, that he is in police
No,
custody.
I will hold this
Allah.
police custody that is granted in the teeth of the order of body warrant by a superior court.
Entire recovery, my lord, is that we have to recover further in about 30 plus.
ಎರಡು ಕೇಸಲ್ಲಿ ರಿಕವರಿ ಮಾಡದೆ ಮೂರನೇ ಕೇಸಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ? Same accused.
39
Same accused.
rupees we have recovered. It is
Same
not, we have not
accused.
recovered. We have so far, my lord, out of 84 crore rupees, we have recovered 40 plus 49 crore rupees is what I have been told. Until 12th is in custody, let them take it after that, my lord.
Take it up.
Let him give.
All right. We'll record his submission.
Please.
Yes.
ಇಲ್ಲ ಅಂದ್ರೆ
ನಾ ರೆಕಾರ್ಡ್ ಆಗದವ್ರು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಸರ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಈಗೇನ್ ನಾನು ರೆಕಾರ್ಡ್ ಐ ಹ್ಯಾವ್ ಸ್ಟಾಪ್ಡ್ ರೈಟಿಂಗ್, ಐ ಹ್ಯಾವ್ ಸ್ಟಾಪ್ಡ್ ರೆಕಾರ್ಡಿಂಗ್ ಎವ್ರಿಥಿಂಗ್.
Not my submission, my lord.
ಅಲ್ಲ ನಿಮ್ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಆಗದೆ ಇದ್ರೆ ಇಟ್ ಶುಡ್ ಬಿ ಹೆಲ್ಡ್ ಇಲ್ಲಿಗಲ್. ಎರಡೇ ಆಪ್ಷನ್ ನಿಮಗೆ.
In fact, couldn't communicate because I was in another.
ಅಲ್ಲ ನಾವೇ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ವಿ, ರಿಟ್ ಹಾಕಿದ್ವಿ ಬನ್ನಿ ಅಂತ ನಾವೇ ಅವ್ರ ಆಫೀಸರ್ಗೆ ಹೇಳ್ತೀವಿ.
Not say.
Yes, on the 12th he'll be handed over to the ED for whatever it is.
13th, 12th is going to finish.
13th morning.
Will be let him be produced.
Yes, so that another order will not come of police custody. The petitioner, Enforcement Directorate, is before this court seeking a direction, seeking quashment of an order dated 3/8/2024 by which the accused is remanded to police custody for a period of 10 days. The accused was initially in police custody.
Sorry, madam. Also for a direction, my lord, to the jail authorities to comply with the.
One minute. In police custody. During the period in which he was in police custody, an application comes to be filed by the Enforcement Directorate seeking custody of the accused for the purpose of examination, interrogation,
Custodial.
for the purpose of custodial interrogation. This comes to be allowed by directing a body warrant to be issued on the said accused to be produced before the Enforcement Directorate for the purpose of custodial interrogation. This happens on 2/8/2024. On the next 2/8/2024 by the Court of Session. The next day, the state files an application, state submits a requisition for issuance of a body warrant on the accused for the purpose of custodial interrogation.
Same day.
Huh?
Application same day.
So and so. This is considered on the next day, i.e. 3/8/2024, and an order is passed by the learned magistrate directing issuing body warrant for the purpose of handing over the accused for custodial interrogation, i.e. police custody. Today, the accused is in police custody. The petitioner has preferred the subject petition. The petitioner Enforcement Directorate has preferred the subject petition directing seeking quashment of the said order. The police custody is handed over up to the 12th. 10 days from 3/8/2024, which would come to an end in the night of 12th August 2024. Therefore, on 13th August 2024, the body warrant so issued against the accused, one A. Satyanarayana Verma, shall stand executed with effect from 13/8/2024. 13/8/2024. ಇನ್ನೇನಿದೆ?
By producing him before the special.
By his production before the Enforcement Directorate.
The special court ED.
By his production before the special court. Yes. List the matter on 21st.
Please.
ನಿಮ್ದೇನು ಹೇಳಿಲ್ಲ.
Can I request an order to be uploaded?
ಇವತ್ತೇ?
ಅಲ್ಲ,
ನಾಳೆ ಸೆಕೆಂಡ್ ಸಾಟರ್ಡೆ.
Monday.
ಮಂಡೇ. ಇನ್ನು ಟೈಮ್ ಇದೆಯಲ್ಲ. Yes, next. ಇಲ್ಲೇ ಮಾಡಿ. ಇರೋದಾ? 4:45. Close it. For the hearing, the Arun ಬಂದ್ರ ಅವ್ರು? ಕಿರಣ್ Arun. He wanted to make few submissions.
15 minutes.
15 minutes.
He's on a parted matter on his leg.
I have a meeting at 5. I have to leave.
I filed all my.
You have filed. He
list of
wanted
authorities I have-
5 minutes.
And Tuesday.
Tuesday, we'll have it on Tuesday.
Serial number 15 is passed.
ನಿಮಿಷ ಇದ್ರಲ್ಲಿ ಯಾವ್ದಾದ್ರು GM ಇದ್ರೆ ರಿಲೀಸ್ ಮಾಡ್ಬೋಣ ಅಲ್ಲ ಅದು ಟ್ಯಾಗ್ ಆಗಿದೆ 3.1 482 GM 1 minute sir ಅದೆಲ್ಲ ಪಾರ್ಟ್ ಹೆಡ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ yes sir
One matter in 1993, serial number 93. Crores of rupees, not the amount of the materials have been stealing in the mall. That has been seized in 2019. As of now, even 3 orders have got from the magistrate to take the position. A part position is taken by the RP to an extent of ground floor. But remaining floors without locking, without security, without surveillance, without even providing any.
My lord, I appear.
Sir,
for
no
the
no
RP.
1 minute this is the case where I granted an interim order to resolution professional
Yes, my lord, I appear.
yes
And he is
3.3.
he is using 40 lakhs rupees have already drawn.
who the RP
RP. And more than 7 crores of materials have been stolen. Even they have not locked it.
this is concerning State Bank of India
Yes, let's get back. And they don't want, they don't bother about this. Well, your lordship has directed to conduct the Mahajar. But as of now, the Mahajar has not been conducted.
My lord, the possession has been taken, Mahajar has been drawn on the 29th.
Well,
And on the
that-
other hand, the complaint has gone.
don't
and,
now you don't precipitate the matter by drawing money and other things till the next date
Not doing that, whatever. it
then
is,
what is
the
it telling
policy.
40 lakhs
Those are the allegations that have been made, my lord.
not after the interim order
After the interim order, as per the directions of the CGM, we've gone and taken possession of the property on the
Possession.
29th.
anyway we'll have to decide it list on 21st in the fresh matters list in the 93 fresh matters list there appears to be more than what meets the eye in this we'll see yes on both sides
Order and so far.
interim orders subsisting interim orders wherever are there they'll continue idu matra 21st hack
The interim order was granted by the Zan before, but they are not cooperating with the police for even for the investigation to conduct the inquiry, to control the Mahajar. Even RPS also is not
ಅದು
cooperating.
let the police tell sir ನೀವ್ ಹೇಳ್ತೀವಿ Right, we'll see yes if the police tell they are not cooperating with the investigation fine complainant is telling yes
My lords, I appear in 93.1, my lords. We have received notice. We would have to.
93.1 ಏನು
My lords, I appear for respondent CBI, my lords. Connected matter. The matter has been connected. We have received notice, my lords. We have to file objection.
file by 21st you file whatever you want
Lordship,
Serial number 2.
okay ask the officers in CBI to expedite
Serial number 15, my lord. Matter is passed over. But it's a split up case.
ಅದು ಮಾಡ್ತೀನಿ ಕಸ್ಟಡಿಲಿ ಇದ್ದಾರಾ ಇಲ್ಲ ತಾನೇ
Is not.
ಎಸ್ ಅದು ಲಿಸ್ಟ್ ಆನ್ 21st ಅಂತ ಮಾಡಿ 21st in the fresh matters list
With
ಕಸ್ಟಡಿಲಿ ಇದ್ರೆ
lordship-
ಹೇಳಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮಾಡ್ತೀನಿ
with your lordship's kind leave,
ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ
There is no interest.
further proceedings before the concerned court where the petitioner shall remain stayed
Serial
ಹೆಂಗೋ ಅಲೋ ಮಾಡ್ಲೇಬೇಕು ಎಸ್
with your lordship's kind, serial numbers 60, my lord, and 77. I pray that it may.
ಎಲ್ಲಿ
be
ಇವರು 77 ನಿಮ್ದೇನಾ
six-
ಮತ್ತೆ 71 ಗೆ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ರಿ ಹಾ
60 and 77. I pray that they both may be tagged, my lord, and.
60 and 77
Yes, my lord.
I tag the petition 60 and 77 22nd
Grateful, my lord.
yes interim order ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ
To be extended in both.
yes so and so
Number 100, 99 minutes. The single man commission minutes. This is Nagondas.
ಅದು ಅಷ್ಟೇ 21 21st
The difficulty is this, my lords. Even though on the 1st of June, my lords, a request was sent by the BBMP for release of the amount, my lords, even till date, nothing is happening.
all right let's see 21st will take it
Serial number 100, your lordship.
230 minutes, my request.
ಆಯ್ತು 230 ಅದು 230 no madam 21st ಗೆ further hearing 230 ಗೆ ಅಂತಾನೆ ಹಾಕಿ yes
96.
ಹಾ
96.
further hearing ಎಲ್ಲ ಒಂದ್ ದಿನ ಕೊಡ್ತೀನಿ
My lords, serial number 85.
22 23 ಎರಡು ದಿನ ಅಷ್ಟೇ
My lord, serial number 100, 100. B Patil name may be deleted, your lord.
ಯಾವ್ದ್ರಲ್ಲಿ
Third on Latif, Council Latif,
ಒಂದ್ ನಿಮಿಷ
100.
ಲತೀಫ್ ಇದರಲ್ಲ
Our name may be deleted.
ಡಿಲೀಟ್ ದಿ ನೇಮ್ ಆಫ್ BB ಪಾಟೀಲ್ 100 ಅಲ್ಲಿ ಅಷ್ಟೇ
Serial number 20.
ಎಲ್ಲ ಹೇಳ್ಬೇಡಿ ಒಂದ್ ನಿಮಿಷ DA ಆದ್ರೆ ಲಿಸ್ಟ್ ಆನ್ 10th September.
My lord,
Interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
serial number 85, my lord.
23rd, 22nd, 23rd.
230 less.
ಎಲ್ಲ 2:30ಗೆ ಅವತ್ತು. Yes.
I mean 23. 21, my lord. Interim order may be extended, my lord.
Interim orders will be extended everywhere. So don't mention. 97 no ಅಷ್ಟೇ. 22nd or 23rd. 2:30.
serial number 21 ಅಲ್ಲಿ
ಒಂದ್ ನಿಮಿಷ. I'll hear you. Wait.
serial number 21 ಅಲ್ಲಿ matter has to be deferred before the trial court. There was an interim order passed.
ಇದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್.
It is there.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Please.
Yes.
Please.
Serial number 83, my lord, dictation of.
ಡಿಕ್ಟೇಷನ್ ಇದೆಯಾ? ಏನ್ ಸತ್ಯನಾರಾಯಣ ಅದು?
Lord, that is the Pune FIR, my lord, we are sought for quashing.
ಓಹ್ ಎಸ್ ಎಸ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದಲ್ಲಿ ಇದೆ interim order ಇದೆ.
ವಿಲ್ ಸಿ. ಅದು ಅಷ್ಟೇ 22nd, 23rd.
Please.
My lord, serial number 18.
Serial number 78, my lord, dictation of.
ಅದೇ 22nd or 23rd.
Serial number 80, my lord.
ಅದು ಅಷ್ಟೇ 22nd or 23rd, 2 dates ಅಷ್ಟೇ.
My lord,
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. 27th. ಯಾವ್ದು ಮೇಡಮ್? 90? 91? 97 ಇಲ್ಲ ಮೇಡಮ್ ಇದು 22nd. ಇವು 9th ಹೇಳಿ ಮೇಡಮ್. 27th.
23rd, my lords, in item number 97.
No, 23rd, but madam is asking for 27th.
I'll just ask.
27th is okay, we'll find, yes.
I'll just.
27th, yes.
my lord, serial number 84 and 90.
Rudrappa,
Dictation, dictating order, serial number 80.
ಇವತ್ತು 22ಕ್ಕೆ ಮಾಡುವ.
Further hearing, my lord, serial number 94.
ಹೌದು ಸರ್, ಅದೇನೆ. ಅದೇ ಮದುವೆ ತಾನೆ.
ಮದುವೆ.
93.
ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ ಇಲ್ಲಿ?
93 ನಾನು.
ಏನಿದೆ?
SBI.
ಗೊತ್ತು, ಅದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹಾಕಿದ್ದೀನಿ. ಎಸ್.
ಇದು interim order ಇದೆ same.
ಸರ್ ನೀವ್ ಯಾವ್ದಕ್ಕೆ?
Same SBI matter I am appearing.
I have posted it for on the fresh matters on 21st.
Interim order.
That will extend, sir. We'll decide that, yes.
My lord. My lord.
Memo.
My lord, request humble submission.
Memo.
Yes, my lord, one request.
Chamber ಬಂದ್ಬಿಡಿ.
ಇಲ್ಲ my lord.
ಬೇಡವಾ?
Yes, my lord. 85 years age person, my lord. ಮೆಮೊ ಮೂವ್ ಮಾಡಿ.
ಅದಕ್ಕೆ ಸಾಯಂಕಾಲ ಮೂವ್ ಮಾಡ್ಬೋದು ಅಂತನಾ?
ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ಬೆಳಗ್ಗೆ 85 years ಆಗಲ್ಲ ಅಂತ.
ರಿಕ್ವೆಸ್ಟ್ ಅಂಬಲ್ ಸಬ್ಮಿಷನ್ ಮೆಂಬರ್.
ಆಯ್ತು.
ಪೊಲೀಸರ್ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ 85 years.
85 years. ಯಾವತ್ತು ಬೇಕು?
ಟ್ಯೂಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ.
ವೆಡ್ನೆಸ್ಡೇ ಹೋಳಿ ಮೇಡಮ್.
ವೆಡ್ನೆಸ್ಡೇ.
ಎಸ್.
That's matter pertaining to Kalburgi bench.
Matter
pertaining to Dharwad bench matters.
That we will take it on 23rd. Pleadings complete ಆಗಿದೆಯಾ ಕಲಬುರ್ಗಿ?
Not yet, Your Honor. Respondents have been served.
List on 23rd. The pleadings by then shall be completed by the respondent. The objections by then shall be filed by the respondents. Yes. ಧಾರವಾಡ ಏನಿದೆ?
Matter pertaining to Dharwad bench, my lords. One matter, my lord.
ಧಾರವಾಡದ ಯಾವುದು?
Criminal petition 1002006 to the 24. Domestic Violence Act, my lord. My friend is ready to take Wakala to file.
For respondent.
Yes, my lord. I am appealing for the respondent. my
Learned
lord.
counsel so and so undertakes to enter. ಹೆಸರು?
BC Dhanaya Swami.
ಜ್ಞಾನಯ್ಯ ಸ್ವಾಮಿ. BC ಜ್ಞಾನಯ್ಯ ಸ್ವಾಮಿ undertakes to enter appearance for the second respondent, registry to print the name of so and so is appearing for the second respondent. Yes, list on 23rd. 23rd ಬೇಡ, 30th.
I request 30 on Tuesday. I'm sorry, I was held up.
5 ನಿಮಿಷ ಸಾಕು ಅಂದ್ರಲ್ಲ.
2:30 gets on Tuesday.
No, ಈಗಲೇ ಮಾಡಿ. If you are ready, do it. Yes. ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ, ಅದರ್ಸ್ ಎಲ್ಲ ಆಲ್ ಓವರ್. ನಿಜಕ್ಕೆ ನೀವು ಹೊರಡ್ಬೋದು.
Recollect, survey number 26 measured 90 acres and odd guntas, out of which 60 acres was earmarked in the notified notification for reserve forest. The balance area was the B notification, B register statement shows that it is reserved as buffer zone. They claim that survey number 59 to 64 is carved out of survey number 26. And it measures 30 acres. Now, I have filed an affidavit, your lordship may kindly see, on 29th of July 24. They say, my lord, this land was,
ನೋಡಿದಿರಾ ನಂತರ?
they have filed objections to my affidavit also, my lord. Lordship, the para 5.
Three
of the-
affidavits are filed.
No, let him finish. Let him finish.
Para 5 of the writ petition, my lord.
Yes.
They say petitioners are absolute owners bearing survey number 60 to 64, which were granted in favor of PM Puttaraju and TK Damodar originally in the year 1931. Now, I have produced with my affidavit
One minute.
the Lord, the affidavit that I have filed is of the Deputy Conservator of Forest. Now, the records have been verified. I have produced the issue register, my lord, which discloses there is no grant to Puttaraju or TK Damodar at all.
This you argued on the last occasion.
No, my lord, I had not argued.
Ah.
Your lordship recollects their cases prior to the notification itself that these grants were made.
Yes.
And then comes the notification.
See, if I remember, 1933 is the grant.
1931 is the grant.
31 is the
Yes.
grant, 35 is the notification.
Yes,
Correct?
yes,
35 is the notification. By then, it was already granted to them.
yes.
It did not find place in the notification. Because it was a granted land, it did not find place in the notification. Now, are we to put the clock back to 1931 and see whether the grant was correct or not?
My lord, because their land is situated right in midst of the forest. No, my lord, lordship may kindly.
Can you put the clock back to
No, I'm not
100
putting the clock
years?
back. I'm not putting the clock back. Your lordship will see the statement that they have made in para 5 is true or correct. Your lordship will see the issue register does not disclose 1931 grant at all. It's a fraud that is being played. Lord, I've kept-
I take exception
No,
to this
no,
One
statement.
minute, one
I'll
minute.
answer
I'll get
the
back to you,
court's
sir.
query.
Fraud
It's a fraud.
unravels everything andre 100 years ಹಿಂದೆ ಆಗಿರೋ grant. How can we assess now whether it is
No,
fraudulent or
your
not?
lordship may take the original, I may
Pudi.
require. And the revenue officials are also present, my lord. I have produced the certified copy of the issue register. Your lordship will see even the survey, what they produce, the Tiffany, my lord, your lordship may also see annexure C, what they do, my lord. Annexure D, your lordship may kindly take at page 47, my lord. D4, I'll take D4, my lord, for 59, page 59, my lord. This is the Tiffany that records, they say.
Page 59 of?
Page
Of?
59 of the writ petition, my lord. Lordship will see all these documents where they say the land got sub-numbered way long back. They give reference to this grant order. In the bottom page, Lordship will see ಈ ನಂಬರ್ ಪೈಕಿ ರೆವಿನ್ಯೂ ಇಲಾಖೆಯಿಂದ 246
ಹೌದು.
That's the reference to the grant.
Yes.
Lordship will see I placed the original grant.
There was no grant at all?
There's no grant at all. I'm not trying to undo, my lord. Their whole defense, which they have set up in para 5 of the writ petition, is false. Their land is right in midst of the forest boundary.
ಅದ್ರ ಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ಹೆಂಗ್ ಕೊಟ್ರಿ ಮತ್ತೆ?
ಇಲ್ಲ, we are trying to recover, my lord. All the lands.
ಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ಹೆಂಗ್ ಕೊಟ್ರಿ?
ಪಕ್ಕದ land ಕೊಟ್ಟೇ ಇಲ್ಲ. ಒಂದು
Yes, those are also grant. That's his submission.
No, my lord.
Wait, I'll get back. Yes.
My lord, now, my lord, I have placed the issue register, my lord. This issue register does not disclose grant to Puttaraju or Damodar in the year 1931. So their whole story itself is false.
No, one first thing. You say the grant is wrong for the reason that it is in the mid of the forest.
I'm not saying grant is wrong.
So there is
There's
no grant. No grant is
There's
what
no
is wrong.
grant. That's my case, my lord. They have not produced the grant certificate, my lord.
No grant certificate it doesn't have.
They don't have because
It's only produced contemporaneous document.
I have now placed before your lordship the original issue register
Let me
itself.
see.
Lordship, may I
That's all.
kindly have it in the custody of the court?
This I am having, yes.
Yes, my lord. Lordship will see there is no reference to survey number 59 to 64 also, my lord. And your lordship will see it's only 64A proceedings. In 64A proceedings, my lord, even what the Honorable Supreme Court has said in T.N. Godavarman's case, the only defense is whether their land is situated within the boundary of the notified
Forest or
forest
not.
or outside. Now, I have produced the high-level clearance committee sketch itself, which has taken place. Their land is situated right in midst of the boundary forest, my lord.
All right.
That's all is the submission.
Lord,
Lord, one other, sorry, one other. Now, if your lordship sees the objections to my affidavit producing the issue register, which they have. They have filed objections, my lord. They have not disputed this issue register which I have produced, my lord.
dispute.
No, they have not produced any.
Affidavit objection hakidira?
Hakidar.
Okay.
That is filed.
Lord, it is filed on 30th of July 2024.
6. Yes.
My lord, all they say is, lordship will see, document produced as alleged issue register in page 2 of last 3 lines of the page 2, my lord. The document produced as
Yes.
alleged issue register is wholly illegible, and does not inspire confidence.
Adu I should tell.
Really, Lord, from where, Lord, the affidavit is not filed by any revenue department officer. Lord, grant is by the revenue department. Till date, my lord.
This is the grant, this is the
Original issue register.
Till date, my lord, none of the.
So what were you doing till now?
94 years agide ivaga. 1930-31 is a grant. Now, my lord, all those natural consequences that will flow from a grant has happened. 1930-31 is a grant. 33 is the POD and allotment of survey numbers 59 to 64.
Yes, that is true.
That, my lord, incorporated in the village map, comes in the residential zone, converted, Kata has been issued, and my lord, everything has taken place for 94 years. No, if there was no grant, there was no necessity for POD at all. My lord, this should have been inquired by the so-called, my lord, competent authority under the forest regulations when they, my lord, issued the notification itself. Now, my lord, your lordship may kindly see my common statement of objections. I have given an area statement. Annexure AB, my common statement of objections to their affidavits.
Yaudರಲ್ಲಿ objections.
ಇದರಲ್ಲಿ 19th of June 2024 ಅವ್ರು 3 affidavits ಹಾಕಿದ್ರು. ಆ 3 affidavits ಗೆ ನಾನು ಕಾಮನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೇನೆ.
One moment.
What date? Date.
19th of June 2024.
ಅದು ಎಲ್ಲ ಮಾಡಿ.
ಅವ್ರು 3 affidavit ಹಾಕಿದ್ರು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ on 6/6/2024 and 13/6/2024 they have filed 3 affidavits. So in reply to that, I have filed on 19th of June 2024.
Ian, what is your case tell?
Lord, I have given an area statement.
Lord,
Lord, I have an extra copy of this.
ಕೊಡಿ. ಅವರು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು.
ಕೊಡಿ.
What is admittedly notified as forest is 60 acres, 20 guntas. The entire survey number is 91 acres, 2 guntas.
Page.
My lord, annexure 20, page 21, annexure AB. So, even according to them, my lord, the remaining extent of 30 acres, 22 guntas is not notified as forest. Now, your lordship may kindly come to 59 to 64, right hand side only. 59, 60, 61, 62, 63, 64. These are the grants.
All right.
Lord, survey number to the left hand side, my lord, I have shown it as government.
All right.
Adu 68. Survey number 68, 71 ralli, this is an illegal grant, survey number 68.
ನಿಮ್ದು ಎಲ್ಲಿ ಬರುತ್ತೆ?
ನಂದಿದು 59 ಈಗ ಪೆಟಿಷನ್ ಅಲ್ಲಿ 60, 61, 62, 63 ಆರ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಪ್ರೆಸೆಂಟ್
61, 62, 63?
60, 61, 62, 63.
What is 59 and 64?
64 ಒಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್
ಹಾ.
ದೋಸ್ petitioners are not before your lordships, but the facts are same.
But they are not, ಅದನ್ನ what has happened there?
ಅದರಲ್ಲಿ I think separate writ petitions
64 has been issued and they have challenged and it's
Challenged.
pending, yes.
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ. Now, my lord, if your lordships tallies this area available in survey number 68, 69, 65, along with the remaining extent in survey number 26, it tallies to 60 acres to 20 guntas.
ಯಾವ್ದು 4 survey numbers?
ಆ 4 ಸರ್ವೆ ನಂಬರ್ಸ್. ಅದು 71 ನಲ್ಲಿ they made illegal grants. After 35 notification, this survey number 68, 69 and 65 have come into my lord existence in 1971 or so. I have given the revenue documents, annexure S, my lord, is the revenue document. So grants and my lord, the acres which has been granted, and my lord, now it is available with the government. If it is
Tally
tallied,
ಆಗುತ್ತೆ.
60 acres 20 guntas tally ಆಗುತ್ತೆ.
So ಮಿಕ್ಕಿದ್ದು ನೀವಿದ್ದೀರಾ?
ಮಿಕ್ಕಿದಲ್ಲಿ ನಾವಿದ್ದೀವಿ. That is 59 to 64. It is not their case that entire 91 acres 2 guntas has been notified.
No, that is not his case.
So
It is
that
not
is
his
my
case at all.
Now enter 91 acres.
Your lordship may kindly take the notification. What your lordship also saw, there is a B register statement.
No, if
42.
entire 91 acres was forest land, how did everything come up now?
28 acres is earmarked. What happened, my lord? Between on the western side, if lordship sees, the surveyor was specifically appointed by virtue of this honorable court's direction to identify the western boundary. He deliberately does not identify the western boundary at
Who
all.
does not?
The ADLR, my lord. Therefore, I file my objections to
Your
that.
officer.
My own
The
officer
eastern
plays
boundary.
fraud and does not identify. There is a high level
No.
clearance committee sketch which is prepared and produced, my lord.
Ah.
Now, the B statement which is produced, my lord, shows this extent of 28 acres, nearly 30 acres, was earmarked as buffer zone between the agriculture land situated on the western side. The B register statement says a margin of 5 chains between the forest line and Hidwalli lands as marked on the map may be left as there are Hidwalli lands
So, all
all
right.
around.
How much extent are you holding?
30 is what
My
he
lord,
says.
32 acres,
All
30
right.
acres, 20 guntas.
What about the others?
No, that is total 59 to 64.
59 to
59
64.
to 64 are total. Astrally 16 acres is the encroachment and the our case.
Forest is 16 acres.
16 acres out of the total 59 to 64. ಅವರು 60 to 63 ಗೆ separate ಆಗಿ notice issue ಮಾಡಿಲ್ಲ. 59 to 64 ಗೆ total 16 acres you people have encroached. They have started the proceedings. That is their case.
Encroachment because there is no grant at all.
No, no.
My lord, encroachment, they are saying, my lord, 1 second. My lord, the entire approach of the forest department, even while they filed statement of objections in 2016 in this matter, is that the grant is pursuant to the notification, therefore you are encroachers anta. That is the approach. My lord, that there they have, my lord,
So all
Right.
your rights or whatever claims that you are now making dates back to 1937.
Absolutely, my lord. That no, we stand by the
35.
my lord, in Nirvana Gowda's judgment, I'll place it
Yes,
also,
yes,
my lord.
that I consider.
Any grant subsequent to the notification is null and void.
Whether grant is subsequent to the notification is what is to be
My lord,
seen.
now, my lord, their grant is, they say prior. Now, they have not produced the grant certificate. Anybody can come and say my grant is prior to the notification. Now,
No, anybody can come and
My lord,
say,
this-
but when do you say? After 100 years?
my lord, once a
my lord,
forest.
ಅದಕ್ಕೆ
My lord, may I
your
just-
lordship,
my lord,
my lord, this court has passed an order. I'll just show that order, my lord, interim order which is
before that,
passed
my lord, one of the latest judgment of this.
on
honorable court.
18/8/22.
Now,
All right.
my lord, where,
Copy ಕೊಡಿ.
good, give it.
ಇದು 30th latest judgment. Yes.
Now, what this honorable court
Once a
has said
forest,
is-
always a forest.
No, not only that. Judicial institution now is a stakeholder. Is a stakeholder insofar as the forest is concerned, my lord. Now I have that para your lordship will find. I'll give it. Have a copy.
All right, we'll consider this.
So therefore, my lord, now I have produced the original issue
is
register itself, my lord, before
RFA.
your lordship. If
RFA
there is
by
no
this-
grant forthcoming, my lord,
All right.
then
yes.
that whole story that they have put forth, even with regard to
So all would hinge upon 1931 grant, 1935 notification, whether the possession is after the notification or grant is after the notification, or prior to the notification.
And one other aspect your lordship may consider, the forest settlement officer is appointed to examine the claims. Now, no claims are put forth. If there is no grant forthcoming, my lord, and if any right was there, they should have placed their claims before the forest
All right,
settlement
we'll
officer.
see.
Sir, Aditya
That's all.
have produced citations to say, my lord, if the survey numbers are not at all included in the notification. Now, my lord, admittedly, PODI has been done, my lord, in the year 1933. 35 is the final notification. So therefore, only 2 years from the date of subdivision. Even though knowing, you know, it is the government, they cannot say that revenue department has done something and forest department was not aware. They were supposed to conduct an inquiry. Number 59 to 64 was in existence. Those lands, my lord, after they are subdivided, they have their separate existence. You can't say that is also 26. Now 59 to 64 have come into existence. They are not included in the notification at all. So
Yes.
therefore, my lord, that extent is also excluded from the forest notification.
Right.
Then, my lord, my lord, your lordship's order.
About 500 acres is thoroughly forest. We have produced this along with the memo.
Lord,
On
18/8/2022.
Alla, which,
On 7
Last time ತೋರ್ಸಿದ್ರಲ್ಲ ಅದು.
2023.
Last
yes.
time you showed
Now,
this.
my lord, this entire is identified as thoroughly. Now they are sitting exactly in middle here, my lord, at the neck.
Ade sketch alli they have admitted our grant. Ade sketch alli
admitted that
ಕೆಳಗಡೆ
they are
there is a table. They say as per this 1930-31 ಬೋಡಿನೂ ಆಗಿದೆ ಇದರಲ್ಲಿ ಇಂಥವ್ರು ಇದಾರೆ ಅಂತ ಅದೇ sketch ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. My lord, for till date, my lord, till he filed this affidavit about a week back, there is absolutely no dispute even by the forest department about my grant. This is some research they have done. I don't know from where, my lord, they have got that issue
all right,
register.
we'll see. Yes.
Where does it
Where
pertain?
from which register ಅಂದ್ರೆ office ಇದು.
ಅಲ್ಲ ಅದಕ್ಕೆ ಯಾವ ಕನ್ಸರ್ನ್ಡ್ ಆಫೀಸಾ ಅಥವಾ ಎಲ್ಲಿ
No, no,
ಇಟ್ಕೊಂಡಿದ್ದಾರೆ?
this is, we'll see. The learned
Revenue
will
officials.
record it, don't.
Yes.
Yes, we'll keep it in.
And one more aspect, my lord, this court's order on 18/8/2022.
That pursuant to which survey is conducted.
No, yes, there is a specific record that there is no dispute with regard to the grant.
Yes.
This
I'll
court
just
has
pass on
recorded
my
after hearing
compilation.
submissions.
Interim orders.
Interim order. how-
Interim
My lord,
observation.
observations are there because, my lord, this matter was heard back then also, and then government did not dispute.
All right.
But, one judgment, my lord, the lordship may also take. The Honorable Supreme Court has said in Narendra Singh's case, my lord, that the government records, the records maintained by the forest
No, this,
department.
there are so many issues to write in this. We'll write.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಇಶ್ಯೂ ಇದೆ ಸ್ವಾಮಿ ಸೆಕ್ಷನ್ 3 ಅಲ್ಲಿ
Hmm.
if only if the land is at the disposal of the government as on the date of preliminary notification, that can constitute a subject matter of the forest.
So as on 1933,
Yes, 1935.
1935,
1933 is a
33 preliminary notification, 35 final
final
notification.
notification. So as on
So
that
as
date,
on 1933 preliminary notification, your grant was already made
already
according to
made.
you.
It was not a land at the disposal of the government. What is land?
And
at the
it did
disposal-
not find place in preliminary notification
Exactly.
because the grant was made.
Yes.
That's
yes.
his case.
Just
That's
two-
your
Two
case.
more sentences.
Yes.
Two more
And-
sentences, my lord. Survey numbers are not mentioned in the any notification. It's
Yes.
only by boundaries.
Yes.
No.
Insofar as lordship may kindly see, my lord, we are relying upon the boundaries mentioned in the notification. We are standing by that notification. my lord. And so far as they are concerned, my lord, the whole story is on grant. Your lordship may kindly take
Whole
the
story is on
register, that's
grant.
all. If the grant
Oh, whole
exists,
story is on grant.
my lord,
Your defense is no grant.
and revenue documents cannot be relied upon to prove title, my lord. If grant certificate is not there, then they're trying to establish their title by
Lord,
virtue of revenue
yes.
documents. That's all.
Original grant ಅವರು ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಕಟ್ಟಲಿಲ್ಲ ಅಂತ ರೆವೆನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ forfeits the land and auctions it again by taking money. ಕನ್ವರ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ದುಡ್ಡು ತಗೊಂಡಿದ್ದಾರೆ. Now, my lord, they say there is no grant at all.
We'll answer everything.
Yes, my lord.
With the original records.
Submission, my lords. Grateful, my lord.
Obliged. Deeply obliged.
23N.
Even is done by the food inspector as well as the village accountant, my lord. DSP is the officer, my lord. You-
Allow ಮಾಡ್ಬಿಟ್ವಾ?
ಅದು ನೀವು ಹೇಳಿ ಸಂಜೆ ಅಷ್ಟೊತ್ತಿಗೆ ಹೇಳ್ತಾ ಹೇಳಿ.
ಹಾ?
ಸಂಜೆ ಅಷ್ಟೊತ್ತಿಗೆ ಹೇಳಿ ಅಂತ ಹೇಳಿ. 23.
ಅಂದ್ರೆ it's in accordance with law. Then ಅದರ disposal ತೋರಿಸ್ಬಿಟ್ಟು ಸ್ಟೇ ಆಗಿದೆಯಾ? ಸ್ಟೇ ಆಗಿದ್ರೆ will vacate it. ಡೇಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀವಿ? Then 22nd, fresh matters. That day, be ready with that. We'll, if there's anything, we'll vacate.
Serial number 89, further hearing, my lords.
ಯಾವ್ದು ಅದು ಚೆಕ್ ಬೌನ್ಸ್ ದಾ ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರಲ್ವಲ್ಲ ಏನು
ಅವ್ರು ಬಂದಿದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು ತಾವು ಆರ್ಡರ್ಸ್ಗಿಂತ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರಿ
ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತೀನಿ
submissions.
ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್
23 22 23 ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಇಲ್ವಲ್ಲಪ್ಪ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಇಸ್ ಹಾಲಿಡೇ ಎಸ್ ನೀಲ್
Your Lordship, just wanted to inform that NIOS has issued all the certificates to National Law School
ವೆರಿ ಗುಡ್
and 1 month is complete now in National Law.
ಕಂಗ್ರಾಚುಲೇಷನ್ಸ್
Thank
ಆಲ್
you.
ದ ಬೆಸ್ಟ್
Thank you.
I enquired him, any difficulty was
ಥ್ಯಾಂಕ್
there,
ಯು
he
ಥ್ಯಾಂಕ್
said,
MN you should thank MN Kumar yes
Written
good
submissions.
all the best
I've also filed my written submissions. in that
all
matter.
right we'll see yes great